Good morning, ladies and gentlemen. Welcome to the 561st Board Meeting of the California Regional Water Quality Control Board, Central Valley Region. I'd like to introduce the board members and staff at this time. On my far left is Raji Barr of Bakersfield. Sitting next to Raji is Carmen Ramirez of Atwater. On my immediate left, your right, is Mark Bradford of Sacramento. And on my far right is Dan Markham of Falls River Mills. Next is Bob Schneider of Davis. Sitting on my immediate right is our Vice Chair, Denise Cadera of Allensworth. My name is Carl Longley from California, and I'll now introduce Executive Officer Patrick Palupa, who will introduce staff.
Good morning, Dr. Longley and members of the board. To my immediate left is Adam Lapitz, Assistant Executive Officer in the Rancho Cordova office. To his left is Kieran Lanfranchi Rosardi, the Executive Assistant and Clerk to the board. Across from me, we have David Lancaster, attorney with the Office of Chief Counsel, and to his immediate right is Andrew Altavote, Assistant Executive Officer. Janelle will be helping us on the timer today, Janelle Brown. To my right, we have Jessica Yar, Senior Counsel with the Office of Chief Counsel, and to her right, we have Bailey Toft Dupuis, another attorney with the Office of Chief Counsel. In the audience, there are other members of the regional board. We have Clint Snyder, Assistant Executive Officer in the Reading office, and I also see Yvonne West, Director of the Office of Enforcement here today. So that rounds out most of them. There's quite a few other staff in attendance as well.
Thank you very much. Denise, could you please lead us in the pledge?
Yes. Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
One task that we did not do yesterday was review the minutes. Consider from the
The minutes are actually not agendized, so we'll be doing them at the next board meeting.
We'll do them
It's
at
an
the next board
oversight,
meeting?
yeah.
Okay. We'll move then to agenda item 12. In order to conduct our regional board meetings in a fair and efficient manner, we will be proceeding in accordance with the meeting procedures that have been provided with the summary agenda and are available here at the staff table. And they're also available on request and are posted on the board's website, and they are summarized on the computer screens during breaks. Any questions or comments regarding these procedures may be directed to Karen Lanfranchi Rosardi, our administrative assistant, sitting here at the staff table. Moving on to agenda item 13, are there any board member communications?
Dr. Longley, I'd like to take a moment to recognize my fellow board member, Ms. Carmen Ramirez. She was honored by the City of Merced as Woman of the Year. So I think we'd all give her a round of applause for that. And also, Member Schneider was honored as Citizen of the Year by the City of Davis. So I feel really honored to have such an amazing board that I get to work with. So give Bob a round of applause.
And Dr. Longley, I have it on good authority also that Miss Raji Brar was also named Woman of the Year for her county as well. So congratulations to you. What about the rest of the slouches up here? No?
Only you could say that, Carmen. I appreciate your humor. Well, yes. Well, we've always had good people on this board, and I think that's reflected in the good work we do. I did talk yesterday about the fact that the regional board chairs are having a meeting in April. It'll be April 30th is the date on that. Are there any other comments for board member communications?
I'll bring up a comment about our next meeting in the Fresno area. I'd like to do something in the field. I'm not sure exactly what that might be. I'll leave it up to staff and the board chair to figure it out. But I think it's good for us as a board to be out in the view of the public besides in a meeting room. So that's just my thought.
So the day prior to the meeting or if we have enough time during the 2 days of the meeting, my thought is possibly visit the issue on dairies and possibly visit a dairy.
Absolutely. I think we'll try our best to accommodate that request. It may be the case that we would have to have a separate day, some other time for that type of field visit. We have an exceptionally packed April agenda as well. A lot of matters coming forward to the board, including a number of oil field issues and issues regarding several of the other permitting actions that might take the full 2 days. But if there is time within the board's schedule, we will see if we can accommodate that. If not, we'll try and arrange a separate field tour and board meeting. Certainly accommodating for dairies. I think certainly get into the field is good. We also have permitting obligations that we will try and abide by too, but I'll take that to heart. We'll see if we can make it work.
Thank you very much, Patrick. Any further comments? Okay. Seeing none, then we'll move on to agenda item 14. Do we have any cards for the public forum? Is there anyone here present who wishes to speak on any topic that's not on our agenda? Seeing none, we'll move on to agenda item 15, the executive officer's report.
I have one additional award for today.
Okay. Does anyone wish to speak on, I stated yesterday that we would address the report itself if we had any thing that we wish to state on the report. I think Patrick's already pointed out how he has made the report a little bit more user-friendly, and I commend him on that.
Yeah, I had a question.
Sure, go ahead.
Just one quick question, Patrick, and this is on the enforcement table 4, where we have the notice of failure to submit the farm evaluations.
Yes.
We're continuing to have problems with people just not submitting those things. Is this number any higher than our previous, or?
Let's see, Adam, do you have an answer off the top of your head? I think I think the farm evaluation forms, to a certain extent, it's a better sign than not being in the program at all.
Okay.
So the farm evaluations as authorized in the permit changes that we made yesterday, some of those actually are on a longer time schedule now because certain elements of the farm evaluation stay the same, but I think it goes a lot to the type of communication that we need to have with the growers to make sure that they're well aware of those permit requirements. Again, I view a failure to submit a farm evaluation as something significant. Better that they're in the program and not submitting a farm evaluation than completely thumbing their nose at the board. But we'll try and drive those numbers down. And Adam, I don't know if you have anything else to add on that one.
My mic's not working. I do not right now, but certainly I can find out for you if you'd like to know how that's changed from year to year. If we have that data, we can pull it together for you.
Thank you.
And if Bob is listening, maybe we can get that information even presented to the board later on this afternoon as part of the enforcement update. But if not, I'll have an explanation in the next executive officer's report talking about that number and which way it's going. All right, and with that, there's one more. I know we awarded a number of these Superior Accomplishment Awards yesterday. We have one more today. Janice Cook, if you could come up. And I will say Janice is really one of the very special scientists that we have at the regional board. I've been working with her almost as long as I've been at the regional board, and she always has exceptional insights on the water quality problems and incredible research and regulatory perspective on a lot of the matters. So it's with great pleasure that I'm giving her this award. Janice Cook is a senior environmental scientist specialist in the planning unit. She has provided exemplary leadership in the regional board's Delta Water Quality Program. As part of this program, she has been instrumental in the development of the Delta Nutrient Research Plan, which was adopted by the Regional Board in August. Janice has led stakeholder discussions, technical committees, and has provided coordination with other programs, both internal Regional Board programs and external programs and projects. She has recently led several proposals that successfully secured multiple funding sources to support implementation of the Delta Nutrients Research Plan. Janice is also the Delta Regional Monitoring Program Technical Advisory Committee member, and she leads the Nutrient Subcommittee of the RMP and coordinates with the San Francisco Bay Nutrient Program as well. Janice's technical knowledge, expertise, and enthusiasm on various water quality issues provides a significant resource utilized by many water board staff. Janice is a highly motivated, dedicated staff member, well deserving of this award. Congratulations, Janice.
Patrick, you talked about it, some of Janice's most recent accomplishments, but in my first go-around here, somewhere around the year 2000, I had the opportunity to work with Janice on the Clear Lake TMDL for nutrient and also for mercury, and the Cass Creek TMDL for mercury with Bear Creek, and a number of other programs. So thank you, Janice, very much.
And I'd like to, and I see Janice in the hallway, and I just tell her that when I see her name on a presentation or I see her name on something, it just brings a smile to my face, because you have, I mean, in addition to your technical expertise, you just have a very sparkly way about you, and I really appreciate it.
Yeah, absolutely, absolutely. Her enthusiasm is contagious, even when we're talking about partitioning coefficients with methyl mercury, which is something to, which is an accomplishment in and of itself.
Thank you, Janice, for your service.
All right, Janice, try to leave.
We'll move on now to agenda item 16. This is a time and place for a public hearing to consider adoption of uncontested items 24 through 27. Those include waste discharge requirements and enforcement, MPDS permits, waste discharge requirements, MPDS permits, time schedule order rescissions, also change of name and ownership. Does anyone wish to discuss any of these items? Come forward, sir.
Thank you.
Which item do you wish to discuss? And
Item 24A, Mr. Chairman, we were requesting that this matter be moved off of the uncontested calendar up to a contested matter for purposes of this proceeding.
If you could identify yourself for the record.
I'm sorry, I apologize. James Ardies, representing Sandridge Partners, law firm of Baker, Manick, and Jensen, Fresno, California.
thank you. We'll consider that item separately. Whether or not we move it off the uncontested calendar is yet to be determined. So we will consider all other items. Is there anybody wishing to address any other item on the uncontested calendar? We'll return to you, sir, in a few minutes once we get through.
Fine, thank you.
So we'll do 24A separately.
One item to note, Carmen, you contacted me. Out of an abundance of caution, Board Member Ramirez stated that she will recuse herself from items 24E and F. So I suggest that we have three considerations for the uncontested
Okay.
calendar today. One, for all the items, and Carmen, I suggest you stick around for this one, all the items except items 24A, 24E, and 24F.
Okay.
So with that, Dr. Longley, I would make a motion that we approve the uncontested calendar with the exception of A, E, and F.
Are there any late revisions?
Oh, let me see.
There are some late revisions
Okay.
for 25B.
Okay.
You
Could
have them.
give us
in-
those.
I believe you either have them in front of you or Kieran will be passing them out. This is really a very small change to the MPDS permit, changing the monitoring over the diffuser of an outfall from once a day to once a week. The discharger is fine with these changes, and staff recommend that we make this late revision.
Will you amend your motion to include the late revision?
I do so.
Do I have a second?
I'll second.
Carmen's moved and Denise has seconded that we accept that we move the uncontested calendar except for 24A, E, and F, and with late revisions. Call the roll.
Ms. Ramirez?
Yes.
Ms. Brower? Mr. Bradford?
Yes.
Mr. Schneider? Dr. Markham?
Aye.
Ms. Kadara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you. We'll return to 24E and F. Just step off the dais, please. Do I have a motion for 24E and F?
I move that we approve
I-
24E.
I do have some late revisions for 24F.
Okay, give us those.
Okay.
Those are the ones she already handed out. Okay.
This is a typographical change again, for monitoring, removing it essentially, instead of sampling for total nitrogen mass loading, they'll be sampling for plant available nitrogen mass loading. The discharger is fine with these changes, and staff recommends you make them.
Very good.
And before, I would suggest actually, before consideration of this item, I'd like to put a personal note in thanking staff and thanking Morningstar and Liberty Packing for really working together on this item. If those of you who have been on the board for a few years know that we had a fairly acrimonious hearing involving Morningstar and potential violations at the Morningstar facility several years ago. We have worked very diligently to patch up relationships and to try and put violations behind us, put litigation behind us, and move forward in a cooperative manner that's protective of water quality. The fact that these two items are on the consent calendar here today, I think represent a testament to a lot of hard work and a lot of cooperation that didn't have to happen, and that really needed both the regional board staff to work cooperatively and Morningstar's management and technical staff to work cooperatively with the board. I think we've got two permits here that are tough, that are fair, that are enforceable, and that will let this business continue onward and be protective of water quality.
And I have to thank you and your staff for making this happen, and certainly the Morningstar folks. I had a motion. Mark made a motion, I believe. Does that include the late revision?
Yes.
Do I have a second?
Second.
Mark's moved. Raji has seconded. Reggie has seconded the motion. Call the roll, please.
Mr. Bradford?
Yes.
Ms. Brower?
Yes.
Mr. Schneider? Dr. Markham?
Aye.
Ms. Kadara? Dr. Longley?
Yes.
Motion carries.
Thank you very much. That takes us back to 24A, City of Lemoore and Leprino Foods, Stone Ranch Property, Kings County. Mr. Palupa, do we have a, yes, if you could state your concern, sir.
So I think if we could, staff are prepared to give a short presentation providing some context for the matter before you today. We also have copies of the waste discharge requirements. It's my recommendation that, even though we've had late comments that have been suggested to be submitted into the record, For the board's reference, I have communicated to the folks who have submitted late comments that they will not be accepted into the record after consulting with the board chair, who is acting as a presiding officer for pre-hearing motions and for these type of decisions. My suggestion is we have a dialogue on these issues, but that we take a couple minutes recess beforehand to get staff situated, if that's the board's pleasure.
Certainly. So we'll start out with the presentation, and then we'll hear you, sir. And we'll take that recess now so staff can set up.
And I think at the onset, even before the presentation, we invited the late commenters, and Mr. Ardice is one of the ones who submitted late comments, to have a discussion in front of the entire board about the late comments to again prevail upon the board as to whether those comments would be admitted or not. So I think that after we take a short recess to get everybody situated in the right place, I think we'll have that discussion and then have a discussion and then have a brief presentation by board staff,
We'll go
followed
with
by
board
comments.
staff, then followed
I'm
by
just
the
curious,
comment.
in terms of process, do we want to do this right now, or do we want to move ahead to the next item, or?
It's entirely within the board's pleasure. I will say, is Felix here yet? Okay. We have somebody for the Musco Olives that's running just a little late, so we can't really move forward with that one. If it was the board's pleasure, we could also move directly to item 19, the Mule Creek State Prison item, and defer 24A to a little later. So
I would suggest that we, to board members, that we continue with this item now and go through the agenda.
Yeah,
Thank you. So
I think just having the process questions is important, but I'll support your.
I appreciate that. How long do you need? 4 minutes?
just a
5
couple
minutes?
minutes, yeah.
Couple minutes. We'll stand in recess till board staff is ready. Thank you. Are you ready to go? We're back in session. We're starting off with the staff presentation on item 24A. No.
And just to introduce this item a little bit, last year in April, the board, at the board meeting in Fresno, the board heard about a time schedule order involving these same entities, except for Stone Ranch, involving City of Lemoore, Leprino Foods, Sandridge Partners, and the dire straits that the City of Lemoore found itself in when their wastewater option, the land application areas where they were applying a combined waste stream from the City of Lemoore and Leprino Foods, was essentially cut off from them by a contractual dispute between a couple of the entities in the area. That left the City of Lemoore and Leprino scrambling to find a place to put their treated wastewater, and that led to a time schedule order, extensive negotiations on almost a weekly basis that Scott Hatton and the Fresno staff engaged in. We thought we were on a good track in April of last year, finding an interim solution, and then we thought we were on a good track getting a permit for essentially a Plan B wastewater disposal option together for the City of Lemoore and Leprino Foods, but we have had an entity contest those items. Sandridge Partners is contesting them at the current juncture. I think initially, Scott, before you begin your presentation, we'll have Sandridge Partners talk to the board because they wanted to renew their request to submit written comments into the record. Again, it was late yesterday that after consultation with the board chair, we suggested not including the written comments into the record. We have knowledge, and Sandridge Partners admitted that they knew about the WDRs in advance of the comment deadline. They were engaged in negotiations with a number of the other players in the area, but did not submit written comments by the close of the comment period, which was, I believe, December 31st of 2018. And then we received written comments just earlier this week from Sandridge Partners opposing the issuance of the waste discharge requirements. So at this stage, I would invite Sandridge Partners representatives up to the microphone because they essentially asked to renew their request to submit written comments into
The issue, though, those comments were received by the board when, specifically?
the time on that.
Specifically, Dr. Longley, I believe they were submitted, formally submitted, I believe it would have been Tuesday evening.
Tuesday evening, and they were, so that would take us to February.
Apparently it
6th.
was Wednesday at 3:50 p.m.
Wednesday at 3:50
My
PM.
mistake.
Okay, and they were due in on the 31st, is that correct?
31st of December.
December, okay. Yes, sir.
I think that perhaps a little more context is necessary for this before I go to the issue of the admission of documents, and I don't want to take up unduly an amount of time. But as this board is aware, Sandridge Partners.
Sorry, one second. Janelle, this is a procedural matter, so we don't need to run the clock on this one. Thanks.
Oh, thank you. After years of doing this, I've never had anybody, well, I won't ask for unlimited time, but anyway. Sandridge Partners was confronted with the disposition of highly saline water from the city of Lemoore, and it is damaging to the property upon which it was being put. And there was an effort made to facilitate an agreement with Lemoore. It became very difficult, but through, and I acknowledge this, through the intervention of the State Water Board and the staff, including Mr. Hatton and others, Mr. Rogers, we were able to work out an agreement. Leprino Foods, which is a cheese plant located in Lemoore, is somewhat collateral in the sense that they discharge into the city's waste system. And that was part of the problem. The discharge into the waste system accelerated and significantly increased the salinity of the water, probably 4 to 5 times over what the levels were in the contract. Through the good offices of the Water Board, and we have had numerous meetings, and we were able to forge a contract that placed this water on delisted or de-designated property, and that was the contract that was entered into. And currently, we are receiving the discharge waste onto Sandridge property, not the specific delisted property, but there is no immediate concern about the receipt of water. And I also want to say that Sandridge Partners never at any time indicated to the city of Lemoore that it intended to turn off the toilets, so to speak. Made it very clear that we would give ample time in order to facilitate discussion. I don't think anybody can indicate to the contrary. We've had monthly meetings. We've had weekly meetings with the board members. Leprino has been on those meetings. Mr. Palupa has been on some of those meetings. Everybody has made an effort, but concurrent with that effort, huge amounts of money have been expended by Sandridge Partners to find a way to accommodate the city of Lemoore and consequently the Leprino Foods. And I'd also say that this also implicates the city of Kettleman, which is a disadvantaged community, which places its water into that system. So having said that, and addressing the issues specifically before you today, we, Sandridge Partners, were totally unaware that during the pendency of this agreement, and I have to say with respect to the agreement allowed a 2-year term subject to a temporary order accommodated by the Water Board to make sure that everything can be done while people applied for WDRs, and that was the duty of Leprino Foods. And pipelines were to be built. This is a very expensive endeavor, $2 to $3 million in pipelines, huge amounts of money in engineering, other accommodations that we've had to deal with other public entities. We were totally unaware that during the pendency of this agreement that Leprino was negotiating to purchase a piece of property and pursuing WDRs. We had no idea that that was going on. We had no idea of the purchase price. And in December 13th of this last year, we became aware inadvertently that there was an application for WDRs pending before this entity with respect to what you've heard referred to as the Stone Ranch. That's the first we knew of it. We immediately called and spoke to Leprino's counsel, with whom we thought we had a good relationship, and wanted to know, frankly, what was going on. We were deep in financially. Leprino, I'm not going to get into issues with respect to that, but Leprino, this was December 13th, they wanted additional time to talk. We were trying to talk to them. We have engaged in numerous discussions with them. And in terms of our late entry was precipitated by the fact that we did not know until December 13th that this was going to happen. We never received notice, which is contrary to the regulations of an interested party. We were clearly an interested party. We never received notice. Had we had that, we would have had more time to address this. We tried to address it by dealing with Leprino. That has not been successful. And we tried to encourage Leprino with respect to the current contract. So having said that, we submitted to this entity a comment letter. And it is correct that that comment letter was not received until a short time ago, although, when I say short time ago, several days ago, although I do want the record to reflect that Leprino was given those comments 2 weeks ago. So it's not like they haven't had them. The other thing is, so with respect to the issue of good cause, and with deference to Mr. Palupa, I would point out that we have good reasons why we didn't do it. It's not like we have been recalcitrant. It's not like we have been obstreperous, and it's not like we're tending to obstruct. This is a very, very serious issue. As I'm sure the board is aware, they've been through it. With respect to the issue of prejudice, Mr. Palupa's email indicates that the parties may be prejudiced. Well, there's really only 3 players here, possibly 4. There is the city of Lemoore, there is Leprino, which puts its water into the discharge of the city of Lemoore. There is Sandridge Partners, and there is this board. And with respect to that, what was submitted to this board was a review of the board's proposed WDR. It is not an evidentiary document. It does not involve disputed facts. It merely shows where we believe that this WDR needs to be reconsidered because of applicable law, including SEQA. Mr. Palupa kindly asked that told us that he was not going to do this. He was going to recommend against it. I honestly do not understand that. I can appreciate that getting into a contested hearing on disputed issues of fact is one thing, but simply reminding the board of applicable law and asserting before this board that in material respects those rules and regulations and statutes have not been followed is not a prejudicial matter. You can't close your eyes to that. You're obligated as a matter of law to follow the law. So there is nothing in there contrary to that. I would urge the board to accept that. And the other thing I would do, and I don't want to get into the issues directly involved in that document in deference to Mr. Palupa's request, but I do want to point out that the gravity of this is substantial. This will not only affect the city of Lemoore, it will affect city of Kettleman, a disadvantaged community. It will affect Leprino Foods, which is a major employer. We acknowledge that. It will affect Sandridge Partners, and it will affect tremendous expenditures that have to be made. And therefore, we request that this matter be postponed so that these issues can be addressed. And I think that that is appropriate. And so I'm asking that our comments be accepted. I'm asking that this matter be postponed. If the commission declines to do that, that is the commission's prerogative, but I would request that that be done, and alternatively then, of course, when it comes my turn to speak, I'll address the issues that I'm permitted to address with respect to the document itself, and I'm certainly happy to answer any questions or to defer to anyone else the board wishes to hear from.
Are there questions from board members?
I have a couple of questions.
Yes, ma'am.
So I understand that the comments that were submitted on Wednesday were submitted to Leprino Foods 2 weeks ago.
Approximately 2 weeks ago, yes, ma'am.
So couldn't your office have, under reservation of, of rights, submitted them to the board in a more timely fashion, and then simply, recalled them if the issue had been settled? Because what it sounds like to me is that it's like when a case is moving to trial, right? You're trying to settle, and right before, the trial, you just don't settle. It seems like these documents were submitted because you weren't able to reach an agreement at the eve of the hearing. Is that right?
Well, that's kind of right. We were aware of the, for want of a better term, the kerfluffle that would be created by us filing these documents. We were not aware of everything that was going on. We were trying to deal with Leprino, and so we, instead of filing the documents, there was no sandbagging here. We discussed this with Leprino. We were attempting to reach an accommodation. What we wanted to know, in answer to your question, and not as a matter of dispute, what we wanted to know is, are you going to follow through on your contract, which is a long-term deal here, that you can bail out after 2 years, but we expect you to be in this, because once that water is moving there, it will affect the land. It will salt the land. And so we were trying to do that rather than be confrontational and just say, okay, fine, we're going to take it up with the board. We're going to go to the mat here, and you're going to get into a legal fight. That is the rationale. Now, there's been various positions, and I'm sure Leprino feels that we have been very aggressive in that respect. Our motivation, I can only say to you that we have represented our motivation to Leprino as being in opposition as a matter of public policy to this particular request. And that is our position. But we are currently receiving the water, so there's no lawyers' games being played here. Once we knew we had to do it, we did it. We told them we were going to do it, so they knew in advance we're going to do it. If we can't reach an agreement, we're going to do it. And we're not trying to hurt Leprino. But, at this point, it's really comes down to
Protecting your client, yeah.
protecting our client. Yes, ma'am.
I understand that.
And Board Member Ramirez, if I could, just to comment on the conversation that I had with Dr. Longley, and Board Member Kadara was also included in that as Vice Chair of the Board in some of these conversations. I think your question is directly on point to part of our rationale for the discussion. We did not send the WDRs to Sandridge Partners. However, we did discuss with Leprino, who came in to us to talk about the WDRs, whether they were engaged in discussions with Sandridge Partners well before the comment deadline transpired, and they said they were. We had numerous conversations with, as stated, with Sandridge Partners and with Leprino about the issues down there, and it never came up well after Sandridge Partners was aware of the draft WDRs and was having the conversations. We viewed this as a contractual dispute, and I think Mr. Ardice is absolutely right, involving millions of dollars between Leprino and Sandridge Partners and the fate of that wastewater and where it should go, and what pipeline infrastructure needs to be built and who would be responsible for building that pipeline structure. The board was not aware that there was any water quality concerns related to this particular issue until Wednesday. We had heard noise that they were threatening to submit comments, but usually when there are wastewater concerns or CEQA concerns or other concerns with respect to water quality, it is almost always the course of action where the person who is interested in the water quality issues submits the comments to the regional board by the deadline. They continue the contractual discussions that they may have outside of the board's process, and they do not leverage the WDRs, particularly WDRs involving a small community with financial hardship, to try and get whatever they may need to get out of the contractual discussions. That's the main reason why, after consulting with the board chair, we urged that these comments be rejected. They knew about these WDRs. We were informed that these conversations were ongoing, and they opted not to submit those comments to the board, and instead to try and continue the contractual discussions between Leprino and Sandridge Partners. Again, if there were tremendous water quality concerns raised in that letter, I can attest that there are not. Or if there were some issue entirely relating to the dispute between two businesses in that area, this involves the disposal of wastewater from a small community with financial hardship, and that's the reason why I both urge the board to move forward with this item and to reject the written comment letters. I think with respect to CEQA, and our note to Sandridge Partners says that yes, with respect to CEQA, the window is still open for oral comments. They can still be made before the board. We will provide them with the opportunity to submit those comments after Mr. Hatton provides a brief contextual discussion about the waste discharge requirements themselves. But that's really what a party who had notice of these WDRs and had the opportunity to comment but opted not to, that's typically what they're afforded at these types of hearings.
If I may,
Mr.
Mr.
Ardis,
Chairman.
do you
Yes.
desire to address the board on CEQA issues?
I do, but as a matter of my personal integrity, I would like to respond to one comment made by Mr.
Certainly.
Palupa. And that is, we did not know about any of this until December 13th. And I don't know where he gets his information about leveraging anything. Our comments, he has not been a party to any conversation, and I have not spoken to Mr. Palupa about this matter intentionally because I consider it inappropriate. I didn't, so the statements about us attempting to leverage anything, we have not attempted to leverage anything. We have attempted to engage in a discussion. I can state unequivocally on our part that the discussion has had two components. One, that we wanted to ensure that Leprino was going to enter into a long-term agreement and the water was going to go to a delisted, de-designated property.
Certainly. You've made those points previously. The issue of CEQA is an important one. I view, however, though, and by your own testimony, you received these, you knew about the WDRs on the 13th of December. Certainly, there could have been discussion with the board at that point in time if you felt you couldn't get them in by the deadline. We heard nothing from what I can gather from what's been provided to me by staff, and that by itself influenced my discussion mightily with the executive officer. So with that said, I'm going to ask now for the staff presentation, and we'll follow up with that with short CEQA discussions. I don't want to get into lengthy discussions unless board members want to hear more. So we're ready for the staff presentation at this time.
Thank you, Mr. Chairman.
Thank you.
Carl and Patrick discussed wanting to move forward at this time. I'm curious what the ramifications are of postponing this item. I hate talking about those things even, but in this case, I think we need to know what the board's options are and how we proceed on this item.
So my suggestion would be to go forward with hearing this item. The board could then, at the close of the comments, defer this to the April agenda. There were late comments submitted by three other entities: Stone Ranch, J.G. Boswell, and the city of Leprino. Those were also rejected as late comments, but I will say that those were in support, and I'll let Leprino talk about the potential ramifications to their facility with just the matter of moving forward, not with respect to major water quality issues, but with respect to moving forward. And there will be impacts to the city of Leprino if we do not move forward.
If we move forward on this, in my discussions with you, you stated to me that we would be seeing this in the future again with other permits that need to be acted upon. Is that correct?
There is the issue of process in front of the board. I agree entirely with all of Mr. Ardis's characterizations in front of the board. I think there are legitimate concerns out there in terms of his contractual relationship between his client and Leprino and the obligations that they had potentially to accept this wastewater for a long term, whether they're planning for 2 years, 5 years, or 10 years. Who is building this multi-million-dollar pipeline? That was a subject of many, many discussions leading up to the TSO. I would say the most concerning thing that I heard was that there was some reluctance to approach the board when they had concerns. I think we should be the first person contacted. That's why we have the comment period. That's why we have the deadlines. It is a little baffling to me that if there is a genuine issue with respect to the board's tentative permit, that the first person to go to is anyone but the board. We are very liberal about granting additional time for comments when there's concerns raised. I think it's almost I've almost never heard it that the board will not allow an additional 2 weeks, 2 months to comment on this. And when you have a party that was knowledgeable of these deadlines, was knowledgeable of the draft WDRs, had these comments in their back pocket for at least the past few weeks, and we were made aware by Leprino that they were saying that they were going to submit comments very at the last minute. We were made aware of that. And then the comments actually came in literally less than 24 hours before the start of the board meeting. It's troubling from a process perspective about the board allowing that type of thing to move forward.
Not just this one. I'm very concerned about late comments, particularly very substantial late comments. It throws a wrench into how we do business. It throws a wrench into the process. And that's why I wanted to hear this today and move on.
Well,
Thank you.
And Dr. Longley, I support, what the process issue, because, I mean, I can't think of a more, untimely submission than hours before the start of the meeting. And, what I understood the submission to be was something that is, that we would need to read, synthesize, and consider sort of the legal aspects of what's being asked. Well, that seems, even for me as a lawyer, I would need to sit down for some time, read it quietly, try to understand it. But to do that without the assistance of counsel, without being able to discuss with our own counsel, whether these are accurate, not accurate, whatever, persuasive or unpersuasive, that's too much. So the time issue, if we allow it here, then what's the purpose of even having a deadline if we're going to allow things right up to the date? So I'm concerned with that. So I would support that there. But I am interested in hearing the answer to what Board Member Schneider asked, which is, so what happens if we continue? Is there prejudice? If there is, then let's hear it. If there's not, then maybe it's a different consideration.
And my suggestion would be I can't speak for the
understand.
the board's not prejudiced. It's really not a prejudice to the board.
No, prejudice to the city.
Yeah,
I want to hear from them.
I think, and the city does not have many resources, so I think my conversations with Leprino have been that Leprino has been working through these issues on behalf of the city because the city is very strapped.
We'll wait and hear
But
from them.
and so I suggest that let Leprino potentially talk to the board about what the city's perspective is on prejudice.
And let's go ahead with the staff presentation.
All right. Good morning, Chair Longley and members of the board. My name is Scott Hatton, and I'm a supervising water resource control engineer in your Fresno office. I have not taken the oath. I'm not sure if that's needed. So I'll just go
Take
ahead
the
and-
oath.
Not for this
Not
item.
needed? Okay.
No, we should take the oath for this.
You want to go ahead and swear?
Yeah.
Well,
Absolutely.
let's do it this way then. All who are going to testify on this item, please stand and take the following oath. Do you swear that that your testimony will be the truth, and if so, answer I do?
I do.
Thank you.
Okay. This next item for your consideration are new waste discharge requirements for the discharge of combined effluent from the City of Lemore's domestic wastewater treatment facility and Leprino Food Company's industrial discharge to the Stone Ranch property in Kings County. The following slides present a brief history of the discharge and the proposed new discharge to the Stone Ranch property. As you may remember what was presented at our April 2018 board meeting, the city of Lemoore is located 35 miles south of Fresno and has a total of 8.5 square miles and a population of approximately 26,000 people. The median household income, or MHI, is just over $40,000 a year. The city of Lemoore is home to 2 Leprino food plants. Construction began at the Lemoore West plant in 2000, and it opened in January 2003. It is a cheese manufacturing facility that has approximately 1,000 employees. The Lemoore East plant has been in continuous dairy operations since 1910 and has approximately 300 employees. The 2 plants receive approximately 1.35 million gallons of milk per day from surrounding dairies. Effluent from the city of Lemoore's domestic wastewater treatment facility and industrial process wastewater from Leprino's 2 cheese processing plants are combined and discharged to approximately 50,000 acres of farmland previously owned by Westlake Farms under a 1996 contractual agreement between the city of Lemoore and Westlake Farms. The discharge is currently regulated by Waste Discharge Requirements Order 96-050. This aerial image shows the general location of the city of Lemoore's wastewater treatment facility, Leprino Foods in relation to the 50,000 acres of Westlake farmland as depicted in the 96050 WDRs, shown here in yellow. The area shown here in red is the interim application area for the combined discharge allowed under a time schedule order, which will be discussed in the following slides. The Stone Ranch property is just off of this slide to the west of the city. A later slide will show the Stone Ranch property in relation to the city of Lemoore and Leprino. And just remember on this figure, Highway 198, which is up here in the upper left, you'll see it on the slide coming up on a couple of slides. Sandridge Partners bought into Westlake Farms and is now the sole owner of Westlake Farms. In May 2017, Sandridge Partners and Westlake Farms indicated that they would no longer accept the combined effluent under the 1996 agreement due to increasing salinity in the discharge. With an average EC of about 2,100 micromoles per centimeter, the combined discharge exceeds the effluent limit of Order 96050 of 500 micromoles per centimeter over source water. After numerous meetings between Water Board staff and the affected parties, the executive officer in April 2018 issued a time schedule order allowing the interim discharge of the combined effluent to land owned by Sandridge just southeast of the original 50,000 acres. The time schedule order requires the city and Leprino to come into compliance with Order 96-050 or arrange to discharge to an alternate location and submit a new report of waste discharge by 26 March 2020. A long-term permitting solution is needed to ensure that the city of Lemoore and Leprino have a reliable option of disposal of their wastewater. In response to the time schedule order, Leprino arranged to purchase the Stone Ranch property, shown here in green, approximately 3.5 miles west of Lemoore and 4 miles north from the city's existing discharge point. On 28 June 2018, Leprino and the city submitted a report of waste discharge for the discharge of the combined effluent to this new application area known as the Stone Ranch property. A Title 22 engineering report for the proposed discharge of the combined effluent for irrigation of feed and fodder crops on the Stone Ranch property was approved by the State Water Board's Division of Drinking Water on 27 September 2018. And remember, down here on the bottom of this figure is 198, which was shown in the previous figure. The Stone Ranch property consists of approximately 1,900 acres of existing farmland just west of Lemoore. The Stone Ranch property is underlain by tile drains which discharge to an on-site evaporation basin constructed at the site between 1984 and 1985. Discharge of tile drainage water to the evaporation basin on the Stone Ranch property is currently regulated by existing Waste Discharge Requirements Order 98-229. The proposed order limits the discharge of combined effluent to the Stone Ranch property to 5 million gallons per day, includes effluent limits for biochemical oxygen demand, total suspended solids, fixed dissolved solids, and total coliform organisms, consistent with the Title 22 requirements for disinfected secondary 23 recycled water, and requires application rates to be at agronomic rates. WDR Order 98-229 will remain in effect until the discharge of combined effluent to the Stone Ranch property begins. The proposed order requires that written notification to the effect that the combined effluent will be applied to land at the Stone Ranch property be provided to the Water Board at least 60 days prior to initiating the discharge. So that concludes the short summary of the current discharge and the proposed tentative order in front of you today.
Questions by board members?
And I do want to thank Scott for preparing this practically at the drop of a hat to come up with this for the board's consideration.
Very good. With that, then we'll go to cards and we'll return to Mr. James Ardis. And I see with you, you also have John Albee, Deputy General Counsel. Will he be speaking today?
He's
Well, I'd
probably on the
like
other
to say
side.
no, but he has his, I assume he will be, Mr. Chairman, but
Yeah.
I don't know. But I certainly see no reason to include him in the conversation.
Carl, I'm still concerned about the procedure here, and the timing. And
Well,
this is going to go on for quite some time.
I don't expect it to go on for quite
Number
some time,
one.
but.
And number
do-
two, let me finish, please.
Let me see if other board members share your concern. Are there other board members sharing the concern that Bob's expressing?
If Bob could express the concern.
Yeah, number two, there's a lot of information here. I did review the buff sheet, but I wasn't given a lot of the other information until now. And I'm willing to hear a little bit from Mr. Sanders. I'm willing to hear about the cities and what their concerns are, but even that's going to take a fair bit of time.
Bob,
I just don't know if I'm
want-
prepared to make a
I want to
decision.
confine all of these to 3 minutes.
You know, Carl, I mean, are there real concerns here? What are the impacts of our decision? How is this going to proceed forward in terms of resolving, the long-term resolving of this issue of waste discharge for this city and the people that contribute to that? And I didn't hear in the presentation, I know it was last minute, but where the effluent from Kettleman City comes in. Anyway, thanks. Those are my concerns.
Yeah, and I think I take those concerns to heart. I think there were something that we were very worried about moving into this. My suggestion would be for the board to allow a 3-minute comment period from the Sandridge Partners, 3-minute comment from Leprino, and then to make the decision on whether that's sufficient for the board to move forward today or not. I mean, and I think it is a genuine concern. And I will note that Kettleman is not part of these waste discharge requirements. They're in the area, but there are separate permit requirements in place for that.
Thank you. So if you could constrain your comments to 3 minutes, Mr. Ardis, we'd appreciate it.
All right, thank you, Mr. Chairman. Is there a timer here? Oh, thank you. All right. Well, specifically, it is our position that this board assumes the responsibility of lead agency status. It's relying upon a CEQA report allegedly done by the city of Lemoore, which issued a a negative declaration with respect to that. I would urge the board to look at what that was. What that was a determination to build a pipeline and a pump plant. It wasn't a determination as to the discharge of this water. That is before this board. Reliance upon a decision by the city of Lemoore to build or to permit the building of a pump plant and a pipeline is not the same as examining the consequences of dumping 5 million gallons of water a day out in the community. The other thing I would point out is that the area where this is going to be placed is not de-designated property. It is also part of a municipal system that this board has previously regulated. So it is incorrect to say that it is simply a discharge of farm water. Under the CEQA regulations, this requires that there be an evaluation of the consequences of putting in this amount of water. The board has already heard through Mr. Hatton, and I want to tell Mr. Hatton to take just a moment of my time to tell him how much we appreciate the weekly and monthly meetings and his efforts to help facilitate this agreement in order to ensure that these communities did not lose their ability to dispose of water. Now, and that includes Leprino. But with respect to that, the CEQA issue is extremely critical because it is built upon a house of cards. Once you look at the city of Lemoore's actions and realize that it does not evaluate the consequences of the placement of this discharge water on this stone property, only the building of the pump plant and the pipeline, it is clear that there was no evaluation. As a matter of fact, it actually says that they're not evaluating it. So that in and of itself creates the problem of this agency's responsibility. You are a responsible agency under law. You must examine those issues. There must be an evaluation of the impact of that water, and that is what is required. And if you want to look at, for our lawyer here, 12 Cal. 4th, 1773, Local and Regional Monitor versus City of Los Angeles. It's very specific with respect to that. The guidelines require a responsible agency to assume the role of land agency if the EIR has been certified and it is necessary pursuant to guidelines. Here, and I'm paraphrasing very quickly because of my time, so I limit myself to the CEQA issue, but I urge the board to consider the fact and look forward that there has not been a proper evaluation here, and that is a matter of record, and it is internally demonstrated by the document submitted in application for this WDR.
Questions by members of the board? Thank you, sir.
Thank you very much for your time.
Now, next call, representative for Leprino Foods, Gary Carlton.
Mr. Chair, if we're limited to 3 minutes for Leprino in total, I would yield to our speaker, Brian Houghton.
Very good. Brian Houghton, Leprino.
Brian Houghton on behalf of Leprino Foods. I will just confine my remarks to the CEQA comments that were just made by Mr. Ardais, but if you have any questions about anything else he said, I'd be delighted to respond. I'm glad that Mr. Ardais cited the case which is based on CEQA Regulation 15162 because that regulation establishes that someone in Mr. Ardais or Sandridge's position has the burden to show that the water stream, the water quality, is going to be substantially different from the water that's already going out to the Stone Ranch today. Because the water that's already going out to the Stone Ranch today is the baseline under CEQA. And we have here today with us the farmer who will be farming that land Tony Azevedo, and he's prepared to speak to the board if it's the board's pleasure. He has analyzed that. I mention him first because prior to that, we have lots of board staff, geologists, engineering geologists, other scientists, plus people that Leprino hired who have all these kinds of technical degrees as well, every single person who's qualified, who has looked at this, has said, this water is actually, the treated wastewater is actually going to be of higher quality than what the Stone family has been using to farm the property for several decades. It's actually going to improve the quality of the first encountered groundwater. So the fact is that Sandridge can't meet their burden under Section 15162 of the CEQA guidelines, and so there's no reason to pause on that point.
Real quick, we got about a minute left to your testimony. If you could make sure to address the prejudice issue.
Thank you for raising that. The question's been raised about prejudice. Let me say two things about prejudice. Number one is when the December 13 email came from the Sandridge folks saying, we see that you're seeking WDRs for Stone Ranch. We'd like to talk about that. We got together with them and we said two things. One is, yes, we are pursuing them as a backup plan, and it would be imprudent of us not to. Number two, we said, and we fully expect to continue complying with our contract with you. And we are in full compliance with it today and intend to continue being so in the future. So then what happened was time went forward. Our deadline for exercising an option to buy the Stone Ranch for $22 million, which, by the way, Sandridge knew about, was Friday, January 18th. And so they knew about that. We went and exercised the option, committed ourselves to spending that $22 million for an escrow that's going to close week after next. And it was only after that, on January 22nd, when we first heard that there were concerns about these WDRs. So that's some prejudice there. The other prejudice is simply look at the history. In May 2017...
Sir, you made your point. Thank you.
Okay.
Thank you very much. And I have a card.
I have a question, please.
Yes, go ahead.
Sir?
Sir, there's a question for you.
From the city's perspective, what are the consequences of having a delay in this decision?
Well,
do
I
you
can
speak for the city? You don't speak for the city. do you?
I can tell you what I think, and there is the city manager's in the audience.
We're going to
Oh,
call
that's
the
right.
city
You're
manager.
Leprinos.
So you can have me or you can have the city manager, whichever you
I think
prefer.
the city has to speak about that.
Thank you.
Thank you.
And we'll call the city manager since that's the issue. Mr. Olson?
Good morning, Nathan Olson, City Manager, Lemoore, California. Want to thank you for your time this morning and thank the staff for putting this in place for the city to have an alternative place to discharge to. What I'm looking for from the city's perspective is assurities that we have a place to go with our wastewater. It was mentioned earlier that the intent was never to stop the city, but we did in fact receive a 10-day shut-off notice. And the city's capabilities, I have about 2-3 days.
Who'd you receive that from, sir?
From Sandridge Partners.
Go ahead, sir.
So the city, I can go about 2 or 3 days without discharging before I have to do no flush toilet orders. We start backing up into the streets. So from our perspective, I need this alternate location because I need to have more than one option for my wastewater. And I appreciate the fact that we have a plan A and a plan B. And I owe it to our city to make sure that they have assurities that they're not going to be facing public safety issues.
Questions?
Does that answer your question, Bob? I mean, yeah.
And I would add as well that as a third party to this WDR, the city is sharing in the cost of all these infrastructure projects. There's contracts in place that we pay our fair share, proportionate to discharge, to the Sandridge property or to the Stone Land property. So to get some assurities and some finalities, we'll also not have to go back on our taxpayers of the city of Lemoore if I end up putting infrastructures in two places, or I just need to start preparing and planning for that so I can do 218 hearings if needed. Thank you.
Thank you very much.
If I characterize this as an emergency situation, then is that accurate?
I think the question would be better placed to the city manager, but
Good
that's
sir,
certainly how-
could you
that's
come
certainly
back
how
up?
I heard it as well. I know there was extreme urgency, despite the testimony from both Loprino and Sandridge that they will allow this to continue, that the discharge option to continue at the non-Stone Ranch discharge. I would characterize our conversations with the city as extraordinarily urgent when they felt themselves captured between a rock and a hard place with no place to discharge in the future, when we were talking about this about a year and a half ago.
So, Bob, could you ask the question regarding emergency to the city manager?
I'm just contemplating that in light of what Patrick said. But I'll ask that question. Do you consider this an emergency matter?
So it can absolutely become an emergency matter. Right now, with the time schedule order, we have a place to go with our water in the near future. It's really that long-term plan that I need to get in, and as mentioned
Well,
earlier.
what do you mean by near future?
Well, we have till 2020 on the TSO to either get WDRs in place for the different locations. So we're on a time schedule order. So as mentioned earlier, this is really a contractual issue between Sandridge Partners and Loprino. And where I'm concerned is the city could get caught up in this litigation, and if Sandridge is a private landowner and wants to start shutting off water, it affects my city, and then it absolutely becomes an emergency for us. So it just depends how this plays out.
Thank you.
Thank you.
Thank you very much. And one last card, Tony Azedo, farmer. Azevedo. I'm sorry, sir. I'm not very good with names.
I'm not very good at public speaking, so. Good morning, and thank you for the opportunity to speak. My name is Tony Azevedo. I'm president of Wilson Ranch, and I am here to represent my family, Stone Land Company, as the current owners of the Stone Ranch, River Ranch. The Stone family has farmed the River Ranch for 60 years, and we have always tried to be good members of our community and good stewards of our land. It is where we live, and it's where we raise the next generation of our family farm. We have recently made a deal to sell the River Ranch, we call it, to Loprino Foods, with our family continuing to farm that ground. The treated wastewater from the city of Lemoore and Loprino Foods will be farming with that water. I'm an actual agronomist as well, and I have studied the quality of the treated wastewater, and I believe it to be highly suited to growing crops. It is also a better quality than the irrigation water that we have pumped from our wells for several years. The Stone family appreciates the work that you and your staff have put into the Stone Ranch WDR order, and we ask the board to vote its approval. Thank you.
Thank you very much.
Any questions?
Any questions? Thank you, sir, for your testimony. Okay, so at this point, we're through taking testimony. It's our decision to decide what we're going to do with this item, whether we're going to go ahead and approve it today, or if we're going to postpone it to a later date and consider it on a broader scale.
My suggestion would be to still move forward with this. I think David Lancaster, attorney with the Office of Chief Counsel, has taken a look at the CEQA issues and has a couple comments and might have a question for Scott Hatton, if it's the
Counsel,
board's pleasure.
what are your comments?
Members of the board, I am familiar with the case that Mr. Ardice discussed before you, and a local and regional monitor that involved a section of CEQA that involves the shift in lead agencies, and that section is simply applicable here, at least at this point, and ultimately. Well, actually, I have a couple questions for Scott. Would you stand up, be able to respond just yes or no, or, don't worry about it. Scott, was your staff were you given the opportunity to comment, or were you made aware of the mitigated negative declaration prepared by the city of Lemoore?
Yes, yes, we did receive copies of the mitigated negative.
And there were no pressing issues that, you occurred to you that you needed to be, more involved or more consultation was required?
No, there was not any.
All right, thank you. I think that's all. Now, one of the things that I was listening to is that, based on the comments that I heard beforehand from Sandridge, is, I was listening for testimony regarding, significant new effects that, weren't really discussed beforehand or considered by the regional board or the city of Lemoore for that matter. And, I mean, essentially none were provided, including, with the gentleman who operates Stone Ranch. The other thing that's interesting here is that, well, what really is the section of the CEQA guidelines that really are important here is section 15231, which provides that a final, subject to certain exceptions which are not applicable here, a final EIR or negative declaration adopted by a lead agency is conclusively presumed to comply with CEQA, which means that, what does that mean? That means subject to certain exceptions, if a lead agency prepares an environmental document, we can rely on it. That's the whole point of this statute is, or regulation, is to not reopen the door every time a responsible agency it takes an action on the project. And so, I mean, the time has passed. And I will add that actually, the mitigated negative declaration was reviewed as part of this process. And the discharge of wastewater to Stone Ranch was discussed in as part of the project in that mitigated negative declaration. It was not limited to, Sandridge may have issues with the intensiveness of the CEQA analysis in the mitigated negative declaration, but that analysis is conclusively presumed at this point to comply with CEQA. And it was. I mean, it just, that's all that matters.
Thanks, David.
I have a question on the mitigated neg deck and CEQA. Was the city of Lemoore the lead agency on that document?
Yes, it was.
Okay, thank you.
Go ahead, Bob.
I would like Mr. Palupa, please, to just give us like a itemized 3 or 4 or 5 point summary of this discussion and your recommendation, please, for the record.
I think the summary of the discussion, encompassing everything that we heard here today, there were late comments submitted by a party that is currently in a contractual dispute with one of the entities who will be regulated under these waste discharge requirements. The board rejected those late comments but allowed limited comment on the CEQA issue. With respect to the CEQA issue, we did not hear during the testimony new significant effects that would cause us to reopen a CEQA document that is conclusively to be relied upon by a responsible agency. You heard from regional board staff that we were consulted as part of the CEQA process as a responsible agency, and so the appropriate actions were taken under CEQA. And lastly, I think you heard from the city and from the folks who are going to be accepting the wastewater that they would like this matter to move forward. The city feels like it is needs to have this plan B because they do not want to be beholden to a contractual dispute that at any moment might go belly up between the people who are accepting its wastewater and who are operating the pipelines where that wastewater is going to go. And lastly, I think what we've heard from the farmer and from Leprino and from board staff as evidenced in the waste discharge requirements that the wastewater to be applied to the Stone Ranch property is actually of higher quality than the water that they've been irrigating with. So again, no new significant impacts that would cause us to reopen the CEQA analysis were considered here today. It's my recommendation to move forward with this item. Certainly, we can expect a petition of this. I don't know if deferring the action to April would resolve that issue, given the fact that it seems that with respect to the timing, it was heavily influenced by the exercise of an option on a contract. That deadline has passed, and so I think that we may not be in a better situation to consider this item in April than we are right now. I think we've heard the substance of most of the issues that would come before us if we were to continue this matter.
Thank you. And is there any further discussion by members of the board? If not, I'm ready to accept a motion.
I have a comment. I guess I feel like I'm jumping on a moving train here and barely grabbing hold of the caboose.
I think we all are.
Yeah, this is a very complicated subject to bring up kind of at the last minute. And I understand the comments were late and that there were negotiations going on. Given the economic issues around this and some of the certainty that the city's seeking in disposal of their wastewater, I understand that we'd like to get a decision here today. That said, it sounds like the TSO gives the city certainty through 2020, and I'm not sure that 2 more months would matter that much on that timeline. However, I also don't hear any prospect here for agreement between Sandridge and the other parties to this here in the next 2 months. I'm not sure what the prospect for any progress would be between now and April. It doesn't sound very optimistic. So given all that, I'm a little uncertain, I guess, how to move forward.
Well, I will say that the time schedule order does give them a regulatory path forward. I think from the city's perspective, what happened last time is they also had an option to discharge. Outside of the scope of the time schedule order, or outside of the scope of the waste discharge requirements, was where all the action happened. The contractual terms in a contract that the board was not a party to were triggered, and that's what resulted in the emergency situation that happened about a year and a half ago. I think the city is afraid that despite the fact that they have time schedule order giving them a regulatory option, they could be subject to a contractual dispute that even though they had that pathway forward, the contract dispute could put them crosswise and not able to exercise that regulatory option moving forward. I do think, and I would say that you've heard from both Leprino, or especially from Leprino, that they intend to honor their contractual obligations to keep that moving forward. But I know that at times in the past that has, despite folks saying that we're going to honor this, business decisions were made that change that situation. I have no crystal ball to predict whether that'll be the case this time or not.
So, what's your pleasure?
Carl,
Dr. Longley?
you want to go ahead, Carmen?
That's me, Raji.
Go ahead, Raji.
Yeah, I appreciate everyone's comments, and I appreciate the city manager explaining the position of City of Lemoore. Myself, being from a small city before, we've kind of dealt with a similar situation, so I understand the dire need. 2020 is not far away, and at this moment, what's in front of this board, and what we're here to regulate is water quality. So I think it would behoove this board to move forward and not accept the late comments. And I'd like to vote on that, and the motion, I'm not sure how it carries out.
Well, it's simply be a motion to approve the item on the consent calendar, which is 24A.
So I would make a motion to approve the item on the consent calendar 24A.
Is there a?
Carl, I'm going to second that, actually. And
Okay.
I've tried to get answers to questions and process and timing, and I think Patrick's summary here addresses that discussion and those answers, and I think we should move forward at this point in time also. So I'll second this.
It's been moved and seconded. Is there any further discussion? Call the roll.
Ms. Brower?
Yes.
Mr. Schneider? Dr. Markham?
Aye.
Mr. Bradford?
Yes.
Ms. Ramirez?
Yes.
Ms. Cordaro?
Yes.
Dr. Longley?
Aye.
Motion carries.
Thank you. Thank you very much.
And-
Very
and I-
short, first of all, before we have our break, item 17 has already been heard. Moving on to 18. Is the gentleman here from Musco? Very good. I understand there was a huge traffic issue this morning. We will take a very short break, and then we'll hear
If
item
if I
18.
could, real quick, I do want to apologize for the messiness of that item. I will take it upon myself to be more proactive to make sure that anybody who has a dispute about a water quality concern on our agenda knows that they can contact me and my staff ahead of time, and that we will take all measures appropriate to get their comments into the record, extend comment periods if needed, so that the board's process does not need to result in these last-minute, frantic types of hearings before the board. And if any discharger in the audience, I do want to mark this, please contact us if you have any concerns or any problems meeting the applicable deadlines that we have in our notices. We will extend them if reasonable cause is provided.
Thank you, and we will take a short break, and then we'll resume with 18. Be back in 5 minutes, please. Oh, we're back in session. Agenda item 18. Folks, let's take your seats, please. A lot of good conversations going. Yes, I know. You get these CV Salts people together, they just never stop talking.
It's just a party crew.
Yeah. This is the time and place for a hearing to consider revised waste discharge requirements for the Musco Family Olive Company Class II surface impoundments in San Joaquin County. Is there anyone present who is contesting the proposed actions and wishes to present evidence or testimony on this matter? I like the little hands going on. Since there are persons present wishing to contest this item, we will proceed with the hearing. This hearing will be conducted in accordance with the notice of public hearing and meeting procedures published with the meeting agenda. This time, evidence should be introduced on whether the proposed action should be taken. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. You swear the testimony you're about to give is the truth? If so, answer, I do. Thank you very much. Designated parties are Musco Olives, Inc. Musco Olive Products, Inc. Total times allowed for testimony, cross-examination, and closing statements are as follows. Musco Olive Products, Inc., 5 minutes. All other persons are interested persons and shall limit their testimony to 3 minutes. A timer will be used. Now, I did promise you that I'd let you do a video. You can still do the video. Please state, I saw the concern on your face. Please state your name, address, affiliation, and whether you've taken the oath before testifying. Does council have any legal issues?
None at this exact point in time. I think, I'll be I'll be taking part I'll be discussing some of the legal issues here as part of the staff presentation.
Okay, fine. At this exact
Updates at 5.
When? Minute and a
Tuned.
half, minute and 37 seconds. Okay. We'll now begin with staff presentation, please.
Good morning, Chairman Longley and members of the board. My name is Brad Shelton. I'm the Senior Engineering Geologist in charge of the Title 27 Permitting Unit, and I've taken the oath. I'm here to present the revised waste discharge requirements for Musco Family Olive surface impoundments. The proposed order is being contested by the discharger, and they have also prepared a presentation. The Musco Family Olive Company facility is located approximately 5 miles southwest of the city of Tracy on the eastern slope of the Diablo Mountain Range. The facility has been in operation since 1983. The facility consisted of 2 Class II surface impoundments, Ponds A and B, until 2014, when 2 additional surface impoundments, Ponds C and D, were constructed. Pond A was clean closed in 2017. The 3 existing Class II surface impoundments at the facility comprise approximately 14.5 acres. The discharger is proposing to construct 3 additional Class II surface impoundments at the facility, which requires updating the WDRs to allow their construction and usage. A surface impoundment that they use at like the ones they use at Musco, is a waste management unit, which is a natural topographic depression, excavation, or diked area, which is designed to contain liquid waste or waste containing free liquids, which is not an injection well. Surface impoundments regulated under Title 27 are required to be double-lined and have a leachate collection and removal system. The facility processes and cans olives year-round and uses the surface impoundments to capture high-strength processed wastewater that cannot be discharged on the facility's existing non-15 permits that allow for land application of low-strength processed wastewater. The analytical results presented on this slide from samples of wastewater collected in May 2018 illustrate pH and concentrations of electrical conductivity and total dissolved solids in the high-strength process wastewater. Water quality objectives are also included for comparison. This water meets the definition of a designated waste and therefore cannot be discharged to groundwater or surface water. The existing WDRs approved in 2014 did not anticipate additional surface impoundments at the facility and only approved discharges to ponds A, B, C, and D. These revised WDRs before the board today will allow for the construction of 3 additional surface impoundments. This slide shows the location of the 3 new proposed ponds in relation to the existing ponds and the facility. You can see them in the lower right corner. Title 27 requires that an operator of a surface impoundment provide proof of closure funding, post-closure funding, and corrective action funding. Additionally, for all 3 of these scenarios, Title 27 requires the discharger to establish an irrevocable fund or provide other means with the Regional Water Quality Control Board named as a beneficiary. It's about planning for the future. Why are financial assurances, oh, we went back a slide. Apologies. There we go. Why are financial assurances important? Financial assurances are important because operating a surface impoundment is a financial commitment. The surface impoundments may need to be repaired during operation, or they may need to be closed due to damage or end of useful life. There may also be ongoing maintenance required after closure. Here's my about planning for the future line. Apologies. The water board needs to be assured that funds will be available in the event something goes wrong or the surface impoundment needs to be closed. Starting in 1996, the WDRs for the facility required the discharger to obtain and maintain assurances of financial assurances. Beginning with the 2005 WDRs, a requirement that the discharger demonstrate financial responsibility for closure, post-closure maintenance, and corrective action was added to the WDRs. This demonstration was required annually. In October 2005, the discharger submitted a financial means test document in support of the requirement that they demonstrate financial responsibility for closure, post-closure maintenance, and corrective action. Let's talk about what the financial means test is. The financial means test is a financial assurance mechanism that uses various criteria, including bond rating, tangible net worth, and net working capital, to see if a private entity is financially capable of incurring costs related to operating and providing post-closure maintenance. This is done annually by an independent auditor. Essentially, it's a statement that says, trust us, we have the money, and we're going to have it in the future when it's needed. On September 25th, 2018, Water Board staff issued tentative WDRs for the Musco Family Olive Facility for public comment. The tentative WDRs included language regarding construction and discharge to the 3 new proposed ponds and included financial assurances language similar to previous WDRs. The WDRs required that the discharger provide an adequate financial assurance mechanism or establish an irrevocable fund with the Central Valley Water Board named as a beneficiary. On the 25th of October 2018, Musco submitted comments on the tentative WDRs. The comments included a discussion of suction lysimeters used for vadostone monitoring for Pond B, a clarification that there's never been a release from any of the surface impoundments at the facility, freeboard requirements of the surface impoundments, the water quality protection standard due date, and additionally, a request that they be allowed to use, quote, the full suite of financial assurance mechanisms that are presented in Title 27, including means testing. Water Board staff made changes to the September 2 tentative WDRs that address the majority of Musco's comments, with the exception of the use of financial means test as an appropriate financial assurance mechanism. Now I'd like to turn over the presentation to David Lancaster, Regional Board Counsel.
I want to start by offering a little bit of context for the financial assurances requirement under Title 27. So CalRecycle, which used to be known as the Integrated Waste Management Board, only regulates a specific type of waste management unit under Title 27. That is a municipal solid waste landfill unit. What the state board regulations that Brad mentioned earlier do is they actually extend those same CalRecycle requirements to those waste management units that aren't regulated by CalRecycle. And in doing so, they provide that you have to provide financial assurances, i.e. a irrevocable closure fund, or parenthetically, provide for other means, close parentheses, pursuant to the Integrated Waste Management Board promulgated regulations, which means that you have to do what you would ordinarily have to do for CalRecycle as part of, say, for a surface impoundment or for a non-MSW landfill. Essentially, these serve the same purpose, that is to make sure that operators have the financial wherewithal to provide for unit closure, post-closure maintenance, and corrective action. How do you, there we go. Now, pursuant to the Integrated Waste Management provisions, well, Section 22246 governs the use of the financial means test under Title 27. However, there are absolutely no references to closure or corrective action within that section. The only uses of the financial means test actually discussed in those provisions promulgated by the Integrated Waste Management Board are operator liability and post-closure maintenance. Now, additionally, Title 27 defines the financial means test narrowly. They define it as the mechanism by which an operator demonstrates their ability to pay third-party claims and or pay for future post-closure maintenance, which is consistent with the provisions of Section 22246. The bottom line is that essentially under the express language of Title 27, the financial means test is not authorized. It's not an option for providing financial assurances for closure and corrective action. Additionally, if you look back at the regulatory history of Title 27, the Integrated Waste Management Board made it clear back in 1996 and 1997 that they considered the financial means test to be unavailable for use for anything other than post-closure maintenance. At some point, they clearly changed it for operating liability, but this section quoted in the slide you see before you pretty clearly demonstrates that their intent was that the financial means test should have very limited application. Based on this legal analysis, the waste discharge requirements were further revised to provide MUSCO with three options with respect to financial assurances under Title 27. First, they could establish an irrevocable closure fund. Additionally, they could provide an expressly authorized mechanism under the Integrated Waste Management promulgated provisions of Title 27. Alternatively, they could use another mechanism that was approved by the executive officer as being substantively equivalent to an expressly authorized mechanism. Additionally, there was a finding added that the financial means test was not substantively equivalent to the expressly authorized mechanisms. Now, the waste discharge requirements were recirculated for public comment, and after MUSCO indicated it would be contesting the newly revised tentative WDR's order. As a result, it was removed from the December 2018 agenda, and now we're here. Now the hearing on it is today. So MUSCO submitted additional comments on December 27th. Now, MUSCO makes a series of legal assertions in its comment letter from December 27th, and again, they're all legal assertions as far as I'm aware. Okay, but there are two ones that basically stand out. First, MUSCO argues that its surface impoundments are exempt from Title 27 requirements per the wastewater exemption, which is found in Section 20090 subdivision B. Additionally, MUSCO argues that the financial means test is not expressly prohibited under Title 27, and it should actually be allowed for closure and corrective action here. Now, let's start with talking about the wastewater exemption. For the wastewater exemption to apply, three conditions have to be met. The first condition is that Water Board is either issuing WDRs or waiving them, and that's not an issue here. The next one is that the wastewater is not considered hazardous waste. That is also not an issue here. Musco Olives wastewater is not a hazardous waste. The third condition is the problem here. The third condition is that the discharge must comply with the applicable water quality control plans. That is the stumbling block. Now, Musco argued in its comment letter that its surface impoundment liners prevent wastewater from reaching the waters of the state, therefore there is no discharge. Now, the problem with this argument is that any surface impoundment that meets the performance requirements under Title 27 would do the same, which is prevent wastewater from reaching the waters of the state, which means that every surface impoundment, by complying with Title 27, would automatically be exempt from Title 27, which doesn't make a lot of sense. Now, to understand what compliance with the basin plan means, you need to look at another section, which is promulgated by the State Water Board, which is Section 20200 Subdivision A, which essentially taken together reads that waste that cannot be discharged directly or indirectly to the waters of the state in accordance with basically the effluent or concentration limits that implement applicable water quality control plans must instead be discharged to waste management units for treatment, storage, or disposal in accordance with Title 27. Now, the bottom line is that if wastewater needs to be contained, i.e. not discharged to the waters of the state, i.e. groundwater, surface water, it must be contained in accordance with Title 27. That includes the monitoring and reporting, that includes the closure, that includes the financial assurances. Now, again, as I mentioned before, the express language of Title 27 doesn't authorize the financial means test to be used for closure or corrective action. Again, there are no references in the governing statute, section 22246. It is also inconsistent with the narrow Title 27 definition of the financial means test. And there's also clear evidence in the regulatory history that the Integrated Waste Management Board intended to limit the use of the financial means test. Now, the reasons for this may or may not be clear, but it is the financial means test is essentially akin to self-insurance, which does not fully account for unforeseeable financial difficulties that an operator might face that require diversion of funds, nor does it adequately demonstrate that the operator is taking affirmative steps to prepare for funding the full cost of closure. Also, there is also the additional issue of bankruptcy. I mean, ultimately, at the end of the day, the regional board is well within its right to demand compliance with the express language of Title 27. And I'll hand things back over to Brad.
This concludes our presentation of the proposed WDRs for Musco Family Olive surface impoundments. We recommend the board adopt the revised permit as proposed. I would like to enter the case file in this presentation in the record. We are now prepared to answer any of your questions. Additionally, Brianna St. Pierre, State Board Title 27 Program Manager, who has expertise in this matter, is in attendance at the board meeting and can also be available to answer questions regarding financial assurances. Thank you.
Thank you very much, and we'll accept that into the record. Excuse me, any questions from members of the board?
Is somebody going to tell me how much money's involved in this?
I don't have the order in front of me. I believe the cost to close the ponds, the ponds all vary in size, so there's some variance, but I believe it's around $800,000 to $1 million cost to close each pond. And there are 3 operating now, and we're permitting an additional 3.
It's a lot.
Thank you.
So the cost, so you would want them to have that set aside in a trust?
Not necessarily. They can comply with any of the other Waste Management Board promulgated options. There are several listed under Title 27.
And I might add that it doesn't all have to be funded tomorrow. We can do, like a payment plan. Some people that have done irrevocable funds, they start setting aside money so that by the projected end life of the closure for the pond is, and I think it's 30 to 40 years, depending on how it's constructed, so that at that point, the money's there. So it's not all the money today or tomorrow. Does that make sense?
Has financial assurance already been provided for the original, I guess, 3 ponds that were still operating?
The only financial assurance documents that have been provided are financial means test documents.
So we're seeking to not allow this going forward.
Correct.
Okay, and so it looks like on agenda item 18, page 21, finding 76 is the one that has the total projected cost. I know that was a question by somebody else down the way. And then this is $2019, right? This isn't 40 years, this isn't, $2,044.
I believe that's adjusted for inflation.
Okay, all right.
I believe. Also, they have to submit new reports and revise them, updated. So, this is not set. It's not set in stone from year to year.
Okay, that was just sort of a comment. Sorry. Yes.
Any further discussion? Yes.
Do we require this of everyone with these ponds?
We're currently reviewing the status of financial assurances for a number of facilities because of things that have happened with the economy lately, PG&E's bankruptcy. There's lots of questions about how self-insurance would work in the future. Take PG&E, for example. Who would have expected that they would be filing for bankruptcy? But here we are. So, we're reviewing it for a number of facilities.
The short answer is yes, and I think the reference to PG&E is the fact that PG&E has requested financial means test at some of their facilities and provided documentation along the lines of, we're PG&E, the largest investor-owned utility in the United States. How could we possibly ever fail to live through on our closure requirements? And so, that and a number of the other factors has us taking a harder look at these financial assurance mechanisms. Musco, and I will say right now, even before their presentation, I've worked with Musco for many years. We've got a very productive working relationship. I think we're left with, just this issue of revisiting the financial assurances, to make sure that if something did go wrong with their corporation, that there would be funds set aside available to do this type of work. It's not inconsistent with, say, a bonding requirement for a construction project. If something goes wrong, make sure that there's somebody around to pay the bill, whether it's an irrevocable fund or something else. The real line that we're drawing here that we have not drawn in the past, as we probably should have, is that self-insurance, this financial means test, the trust us, we've got the money set aside. It's harder to justify in today's environment.
Any further discussion? Thank you. Thank you very much. Melissa, I'm looking forward to your video. Where's your video?
Background on
Between
Musco.
California's bountiful Central Valley and the wind turbines of Altamont Pass sits one of the most innovative laboratories on Earth, cleverly disguised as an olive company. You may not have heard of them, but inside these 800 acres, you'll find a company innovating everywhere, pulling riches from garbage and taking cues from nature at each step of the way. Day in and day out, Musco Family Olive Company produces one of the healthiest foods on Earth, and they do it in a very healthy way. Their California facility is on the forefront of sustainable food production, where a shrinking footprint is creating a better value for olive lovers.
You can look at health and you can look at sustainability kind of in the same vein, where a lot of times it will be more expensive to do the right thing, but it's actually worth more.
Musco Family Olive Company was founded in 1942 by Niccolo Musco. Son Nicholas Musco grew the family business, and today Felix Musco continues the tradition.
Our company is investing in sustainability. Companies that are paying attention to this, those are the companies you want to be close with on the long term.
Since the dawn of agriculture, salt buildup in soil has perplexed humankind. Food growers around the world have seen productivity shrink due to salt buildup. The salts come from all over.
Gypsum, fertilizers, detergents that you use in your home, salts to cook, salts to soften your water. The uses are very wide and everybody does it.
Musco has been an industry leader on this issue. Their commitment to solving the problem can be seen in every aspect of their Tracy, California facility.
It purrs, but you can't take it for granted, and you always can improve things.
In recent years, Musco have cut their salt and mineral use by 80%.
The first few bites are quite simple, and then it gets more and more difficult.
The next innovation required the assistance of Mother Nature by way of a unique grass called Nipa.
Nipa actually takes the salt up with the water and extrudes the salt crystal out onto the leaf, so it actually removes salt from the soil.
We started it, failed many, many times. We discovered the time of year you plant it, how deep and so forth. We had a big learning curve on how to do it right. Our grounds are green. It's kind of a dream come true.
Musco now has acres of Nipa thriving on the property. Mature plants are harvested and sold to ranchers who say the cattle love the grass's salty taste. To continue to help shrink their footprint, they're digging into every aspect of the business. Literally.
Dumpster dive, yep. Next big environmental milestone was achieving this facility zero waste.
Digging through it is the best way.
That's still a big pile of garbage. That's 2 weeks.
We're trying to find out how much recycling is going into our trash, what improvements we can make. Everyone's really into it.
We are just separating and segregating all the different types of materials. We have all the big stuff out so we can see how much of it could have been diverted from landfill.
Something as simple as just separating it, instead of paying someone to come and pick it up, we could actually get paid.
Almost there. All right, that's the last of it.
Musco Family Olive Company is the first company in the world to be certified with an SQF Ethical Sourcing Level 2. They've now injected sustainability into every purchase decision.
Before we even make a purchase now, we have evaluated the company and then we balance price, the quality of the product, and the environmental footprint of the company. And that ensures that we are partnering with other companies that share our same values.
These are some of the day-to-day things Musco is doing for the environment. It's the kind of long-term thinking Musco Family Olive Company is becoming known for.
If you're thinking 1 year out, you're not going to go sustainability. When you're thinking 5 years out, 10, 20, and you know you're going to be in the business for a long time, then it starts to make a lot of sense.
This world isn't short of great ideas. It's short of people who will and can implement those ideas.
Customers want to support companies who are trying to go green.
Who knew the power of the olive and a group of people determined to make a healthy food even healthier for our planet?
That was a little longer than I expected.
I said 5 minutes-ish. Well, but now you gotta love the company, right? So 'cause that's a good video.
But one of the things I think you are doing, if I'm not mistaken, you were doing at one time, is you were burning the olive pits for energy.
Good morning, Chair Dr. Longley and the other board members. And yes, we had the equipment there, first of its kind, that would take our pits and burn it, and with that, boil the wastewater and clean it. And then we ran a steam engine which generated electricity for the facility.
So, sorry to interrupt. For the court reporter, we need your name for the record,
Sorry,
please.
Felix Musco, and CEO of Musco Family Olive Company. That project is now mothballed. It's an example of us really, a lot of trial and errors over the last couple of decades. Pretty much really when I started to run the business. Prior to that, it was, in a sense, always fighting what regulations were kind of in front of us, and over the years, we've learned that getting in front of regulation is, first of all, it sounds really good. It makes everyone feel good. Our company is on fire about sustainability right now. And at the end of the day, it's not about really doing what's right. It's actually the best way of running a business. It just saves money to be ahead of the game. I would like to say thank you to our, everybody who's involved in getting the WDRs, bless you, to where they're at today. It was very cooperative. We do have one issue on the means test. I think a word was used earlier that is critical in the way that my philosophy in doing business, and that it's trust. At the end of the day, whether it's a customer or agencies or whatever, we're actually, hopefully it's all humans at the end of the day. And my example with customers, when you have a customer you're dealing with just a computer, they don't look at it as a human situation, they don't do well at the end of the day. They may do well for 6 months or a year or something, but they end up, it just doesn't work. I'm standing here today that Musco is here to be trusted. I think we have a good track record. I don't even need to give direction to our management team anymore about what to do, what's right, what's not right. It happens, and I think that they do better things than they're supposed to do today when it comes to sustainability. Just to give you some quick credibility, so we have the two biggest brands in the U.S. for olives. We take in over 50% of the California table olive crop. Our family's completely vested in the business. We have no other things we're focusing on. And when our CPA, obviously audited financials, gives a statement that we are completely fine today and in the future to take care of any prospective liabilities, that's an accurate statement. The idea of putting money aside for things that are basically not in the foreseeable future is, whether it's $1 or $1 million, it's a huge conflict of interest, because we're taking that money today and we're spending it in the future. Everything is on what I know, all of our interactions on a voluntary basis. We closed our first pond, which is the first commercial Title 27 pond in California. We closed it, clean closure, cost a lot of money. We learned a lot of mud in there. It was incredible, but it cost us over $1 million. We're proud to have done it. The next ones will be easier for us. We're in the process of doubling our evaporation capacity today. That's $5 million. We weren't asked to do it, but we know we have the second pond is also old. I think it's 18 years old. and we're going to voluntarily close that. We've been doing the means test for around 5 years. Yeah, I really hope that the board will consider continuing that. And you got my word. We're going to be 100% trustworthy and groundbreaking on technologies for sustainability as we go forward. Thank you very much.
Thank you. I'd like to comment that I certainly do appreciate the fact that you set yourself out as an example, as you've demonstrated in the video, for sustainability. I can see your concern about not being allowed to use the means test, but at the same time, we're looking 30, 40 years in the future. A hell of a long time, and we don't know what the state of the economy will be in that time, but at the end of the day, this board is responsible for water quality. So we are going to be very conservative in ensuring that the kinds of things that we look at today and approve today are the right action 30 to 40 years from now. So, but thank you very much for the video and the way you've taken your company. Yes, Melissa.
Okay, so now I'm going to go into the legal stuff. So really, we're just talking about this one final issue. It was a very smooth process negotiating the permit, everything else. We had this same discussion when this permit came up in 2014, and we got language in there that although it didn't expressly say financial means, it didn't disallow it, and so they have been using financial means. And as we said, 2017, Pond A was closed, no problems, no fund was needed, and it got done. Musco's operations are not hazardous. It's not a landfill, it's food processing waste, and Musco needs working capital so they can continue to innovate and do these kind of sustainable things. The less money they have available, the less of those kinds of things they're going to be able to do. There are 16 options that are allowed under Title 27 in Section 2228, including insurance, and I note that for municipalities, they're allowed to self-insure, and municipalities go bankrupt, so it's kind of ironic. There's other things, letters of credit, guarantees, surety bonds, and then there's this catch-all of a state-approved mechanism. And most of these apply to solid waste landfills and not this type of surface impoundment, which is regulated by the Water Board. The pertinent sections of the rules, Mr. Lancaster talked about them, are the closure fund, post-closure fund, correction action fund, and in each of those sections, it talks about establishing an irrevocable closure fund or to provide other means. So in blue, those words have meaning in law, and I feel like the staff is just cutting those words out and not giving them meaning. There's additional provisions in Title 27 that you can use substitute assurances. You can have one of those 16. You can use multiple mechanisms together. It imposes stringent record-keeping requirements on all types of the mechanisms, including financial means test. It also imposes a depository trust fund, basically as punishment for non-compliance. So if you think that they're not doing what they need to do under that section, you can come in and say, hey, you got to do a depository fund now. And then, as I said, this catch-all for a state-approved mechanism. So a financial means test, although it doesn't specifically have a laundry list of what it can apply to, it does allow for property damage caused by accidental occurrences, which is basically operating liability, which could cover corrective action. And it talks about future post-closure maintenance costs, which is part of, closure and post-closure are very closely tied together. So either you can read this broadly, or you can use the state-approved mechanism to allow for a more broader reading. There's actually no prohibitions in the definition, and I have to say that Title 27 is not the example of very clear regulations, but you have to read all the provisions in concert. And I think the narrow reading by staff is not consistent. It's not consistent with federal law. In their own response to comments in footnote 9, it talked about under federal law how this financial means test is allowed for any type of facility for closure and corrective action. And we're not seeking to go beyond the list of the 16 options. We're trying to use the mechanisms that are on the list, including potentially financial means. And if the water board doesn't think that it has the flexibility, that it can use a state-approved mechanism. But I have concerns with the water board saying you can use some but not others, because under Water Code Section 13360A, you can say what you have to do, but you can't say how. You can order somebody to comply, but you can't tell them the manner of compliance. And we feel like if you're cutting things off the list, that is telling us the manner in which we can comply. So Musco provided surgical markups to the permit language. This is just part of it for the surface impoundment closure. The response to comments on page 7 said that Musco is free to select any of the available mechanisms under Title 27, but then in footnote 13, it says that the use of financial means is not allowed. So Musco's merely asking to be allowed to use anything listed and available in section 22228, and that can include any alternative in subsection 3 that is approved by the executive officer. So we've been trying to have a meeting to sit down and come up with some plan to have like a melding of them, and we haven't been able to set up that meeting. The other issue that came up in the response to comments was that it's no longer lawful to do a financial means test because of some change in the certified public accountant statement standards. And I looked through all those standards and could not find those. And I think that that could be something that is tweaked with, instead of having a negative assurance, have a positive assurance that everything is fine. And that could be pulled in under the state approved mechanism. So what we are asking basically is to work with the water board to try to come up with some language that gives the water board comfort that the money's going to be there when it's needed. We have a track record. They're going to be closing another one that'll give a second track record to show that it's actually happening, and happening with the approval of the water board. Whether we want to defer this and try to come up with that language and adopt it in April, I think that would be great. There's no real driving force that this has to get adopted at any particular time. They're under a current WDR at the moment. So that was our request, and we really want to thank you and all the staff for your help in this matter.
Thank you very much. Any comments or questions?
I have a question, Dr. Longley, and this is for staff. In regards to the amount, the dollar amount, you're saying that they could put away a little bit over so many years, correct?
Can you speak to that? Yeah, I can feel that. One of the findings that's discussed in the order is that the actual closure of a surface impoundment, unlike, say, a landfill, surface impoundments are somewhat unique in that it's our understanding that the bulk of the cost of closing a surface impoundment has to do with the removal of accumulated solids that accumulate over time. And so the longer a surface impoundment has been operating, the more solids there are going to be within that unit, which means that if a surface impoundment unit prematurely closes, that means that, the closure estimates that we were discussing earlier are for closure at the end of the expected operating lifetime of each unit, which means that if for any reason, the surface impoundment has to prematurely close, the actual cost of closure would be less than as provided for in the closure plan, which based on that fact, what we did in this order was we actually set it up to where the cost of closure per the closure plan is prorated according to how long that surface impoundment had been operating, which means that if they actually did go ahead and do an irrevocable fund, they wouldn't need to put aside the full cost of closure at the outset.
They wouldn't.
They would not.
Okay, so I want to get this in perspective because I understand their need for working capital. And for me, I would like to know dollar range. How much are they looking at each month on putting away? How much is it affecting annually? Because I think that's really important to discussing the fact that their need for working capital and how this plays out, instead of just a $3 million after 40 years.
I think Mr. Musco would probably be in a better position to answer that specific question. Sorry, did you need to repeat that question?
You can ask him if I need to repeat it.
We don't know exactly because we haven't had to do that before to parse it out to know how much it would be. But if you presume there's 6 ponds and $1 million plus each, over time, they're going to have to start funding those. And some are going to be closed earlier than others. And, I can't give you a dollar amount that they would, like, every month they have to put amount away.
So to add to that, as he mentioned, there's one of the ponds in existence is older than the others. It's part of the original pair of A and B. A, which has been clean closed, and B, as Felix alluded to, is maybe closed sometime in the future. So you have to take that in consideration too, that they're all very different ages. There's 3 that are going to be brand new, built with state of the art stuff versus the 20-year-old ones. So it's a somewhat complex exercise, I think, but it can be done.
The other concern is, you're putting money away for corrective action, and if they haven't had any releases, you're locking money up for a chance that something might happen. The point of the financial means test is that you have an auditor every year say they have ample money if one of these things comes up. So it's like putting money away to buy the house, and you don't get the house until the end of the time, or you get a mortgage on the house, so you get the house now.
I think another concern is this type of discussion with we buy a crop every year, so we have a line of credit, and we have an excellent relationship with our bank. But the whole idea of having to put funds away in case don't exist in the future, and even if it's $100,000 or $200,000 a year, they basically, in their brains, they add it up. It can be accrued on your balance sheet. I mean, it's kind of a vicious cycle. And I'll give a commitment right here that we'll the old pond we have, we'll clean it up, in good manner, and when the timing's right. It'll be, we don't want to get out of a very proper situation right now, and forever. So I mean, we're here to stay, and I think we've been. Anyway, I said what I said. We're not going anywhere. We're doing everything is right. I understand all the legal points on this. I understand how it's very necessary to have these type of things established in certain situations. I honestly believe that I think this is not one of those situations where we need to lock money up. It just won't feel right.
No, I appreciate your comments, and I understand where you're coming from. And for my fellow board members, being a business owner, he's absolutely correct. When you do put money aside, your banks do take that into account, and it makes it hard for you to do business and increase your business. And he's absolutely correct on that. So I want to make sure that that point is well taken, and we understand that aspect of it, that it will affect him in doing business. So thank you for that.
Thank you.
I'll present a different point of view. I think it's about dealing with depreciation. When you start with an asset, the cost of that asset is really the fully loaded costs over the life of the asset. So this is really about dealing with depreciation and putting money aside to deal with the eventual cost of taking care of it at the end.
Well, another thing to consider on that point is, since this is allowed under federal law for any landfill surface impoundment, the rules here are more stringent than in other states, and we have seen food processors leaving the state, and those are the kinds of things you have to think about. Is if you're going to make it too harsh for people to stay, maybe they leave, and not saying that Musco's going to pack up and leave, but it's something that we have to think about as to whether we're being friendly to business, and they're protecting water quality. This isn't an issue of water quality. They've put in the state-of-the-art liners. They've never had any releases. They're doing all the right stuff. It's just whether they have to set aside an account that they could never touch.
So if I could comment, I think that the discussion has gone a little further down the line of that the only mechanism acceptable to the regional board is a single fund set aside cash that will never be touched. I don't think that's accurate. what we were setting forth in the waste discharge requirements is simply the proposition that of the financial assurance mechanisms that are out there, the financial means test, which we verified and State Board can testify to that if it's the board's pleasure, it just doesn't work anymore. Felix, I like your facility quite a bit. I remember a sunny day going out there and visiting it. There's a lot of cutting edge stuff going on out there. I think what's evidenced in the video is not, by any means corporate whitewashing. It is actually the value system of Musco and how they treat the environment. But I think that there's unforeseen events that happen all the time. Health insurance, car insurance, bonding for construction projects. That's kind of what we're talking about here. Should the worst case situation befall Musco, and we certainly hope that doesn't happen, the state needs assurances that there's funds set aside, whether it is insurance, whether it's bonding, whether it's some type of mechanism. You don't have to pay all the money. Even if the costs are projected there, you can have actuarial findings presented to the executive officer that, hey, we're funding this. This is the insurance mechanism. This will be taken into account if we go sideways. Here's the funds available to fix this. And I will say, unfortunately, and I mean this, from the bottom of my heart, unfortunately, the Central Valley is literally littered with facilities, including former Olive facilities, where the owners had all the confidence in the world that we're going to be around forever, our business model is going to work, and they go out of business, and we've got a highly saline pond with no money to clean it up. Or we have these, and really the requirements in Title 27 are put in place because it used to be for landfills, that the landfill says, oh, we're going to be around forever, we're going to have the money to clean it up. We've got a lot of landfills before those regulations came into place that there was no funds. The landfill went belly up, and the state, in many cases, had to take that liability upon itself to go fix a water quality problem. So I want you to hear the commitment, to work with you to find an effective financial assurance mechanism for Musco that is as least painful as possible, that locks up as little money as possible and let you keep doing your business out there. I just want to, the reason that this conversation is in front of the board is we had the conversation on the phone with Melissa before the December board meeting, and it was my position that in today's age, where I've been party to discussions for financial assurance mechanism, financial means test with PG&E. I mean that's where the example comes from, where they said, hey, there's no way we could ever fail, and now we're seeing them go into bankruptcy. We've got other entities that said, no way we're ever going to go out of business. They've gone away, and we're left holding the bag. The state's left holding the bag with the water quality concerns that don't have any funds to clean it up. So I just wanted to have this discussion in front of the board today to see if it's the board's position that my feeling that financial means test, and the state board agrees with me, is just not an appropriate mechanism anymore. The trust us will be around. We're committed to the environment, and we can clean this up in the future. It's just a mechanism that is just not as effective as dealing with the water quality problems these days.
I have to agree with you, Patrick. One of those sites is a former olive company in Tulare County that I'm very familiar with, and we thought at one time they were cutting edge. But if you examine you put up section 22228 of Title 27. There's some 16 mechanisms under that. Only one of them is the financial means test, and so as I'm understanding Patrick's statement, that the board is committed to work with Musco to find something that has a little more assurance 30, 40 years out that we're not going to add to the sites that are cleaned up. And I might add, on the site in Tulare County, completely different geology than you have at Musco. I recognize that too, but we didn't appreciate that way back when.
So let me ask a question. So that code section that you just talked about the 16 mechanisms, and the financial means test is one of them. It's in the code.
Yeah.
And it's a statutory code. It's a
No, it's in the regulations. It's in the Cal Recycle Financial Assurances Mechanisms within Article 2, Division 2, Chapter 6 of Title 27. Some of those mechanisms are eligible for these types of facilities, others are not. And really what we're saying in this hearing today is, and again, backed up by the state board saying that that's not appropriate for this type of impoundment. Some of the others are. And so, and frankly, as Melissa stated in her presentation, other state-approved mechanisms that do the same thing would be allowed. So we can be creative in terms of coming up with our solution. But the default, the position that was put up by David Lancaster, is irrevocable fund. So that the default is irrevocable fund, and then we operate for something that would be as effective as irrevocable fund, and that can take the form of insurance, that can take the form of bonding requirements, that can take the form of a lot of different creative tools that can be reasonably conceivable that the board will have the money, the state will have the money to address this problem if things go bankrupt. And frankly, I have some familiarity with construction bonding. Your bond is in part dependent on the health of and assets of your particular operation out there and the risk that your construction activity poses. So all that can be taken into account by financial folks when they come up with a bonding mechanism, when they come up with an insurance mechanism. That's really all we're asking for.
And as I understand, Patrick, what we're talking about, and this is a policy decision this board has to consider, I think, as we go forward. It's not just Musco. It's every other entity out there.
And I understand that, but there's two reasons for my question. One is I want to make sure we're not taking away an option that the legislature has created, right? Because, if the legislature said it's okay, but we don't like it, then, that's not something that we can do, right? The second part is that I'm very sympathetic to the position that, we've been doing this for this long, we've never done anything wrong, and now we have to come up with this new expense that wasn't projected, and I understand that this is sort of a bellwether case, and, you guys are sort of in front of us, but it does seem like an unfair surprise to say, hey, we've been doing it this way, now we got to reconsider. I understand why we're doing it, and PG&E is exactly what came to mind when the presentation started. So, this is something that I struggle with because the law seems so clear. When David Lancaster was done, I just thought, all right, this door is closed. What else could, Attorney Thorpe say? And then there's the reasonable part. And then we're really called to, operate in this difficult sort of area.
Right, and if the state board doesn't want to use that anymore, they should change the regs, so that it's not an option anymore.
So I will say two things. One, they are changing the regs, and that process is underway to make it crystal clear. And again, as I've alluded to, Brianna, I don't know if you want to come up and have a couple words.
Well, yeah, but
if it's the board's pleasure.
Before we do that, we have a couple board
I
members
have a
want to talk.
question.
Bob,
Yeah.
go ahead.
These ponds, the cleanup cost of these ponds should be on the books in some form in any case. So that's a liability that the company incurs when they do the ponds, and that's what you were alluding to. PG&E actually has had 2 bankruptcies that I'm aware of, anyway. And so that it just, things change, and you alluded to Family Health or something. And a couple other examples are, we have Iron Mountain, and that was a settlement, and that was done, I think, with a fund set aside or bonding for a fund set aside to
AIG
provide
has a fund
cleanup
set
over
aside.
time. Another one is Homestake Mine, gold mine up in Napa County, north into Napa County above Lake Berryessa. And they're doing a very, very thorough cleanup. And when Barrick Mine actually purchased Homestake, I'm not quite sure they understood the liability. They were buying all the assets of Homestake Mine, but there was a couple liabilities. And they've actually done an exemplary job of following through with that. But they were on the hook for it too. And I think, I was in construction for 20 years, and we dealt with bonds a lot. And I think our board needs those assurances. And while actually I quite appreciate your company also, and I value your recognition of trust, but in this case, as a regulatory entity, we need to rely on some form of financial assurance, and I think, you know, a bond or a fund or that's paid over time is actually an amenable approach, because the reality is when you build the pond, you've incurred as a cost of building that pond, the liability for that cleanup. And one way to recognize that is on the books is either just that liability or the cost each year for the fund. So thanks for listening.
And Bob, you mentioned Iron Mountain. In the next decade or so, this board will be discussing Iron Mountain because that fund is disappearing very rapidly. Go ahead, Mark.
Yeah, I wanted to thank you guys for coming in too, and obviously you're doing the right thing on a lot of fronts. And I really like your logo, by the way. Reminds me of my kids eating olives. But I guess my observation here, and I haven't heard any of this before the meeting today really, is that you know, we have to have the same rules in place for everybody. And although you guys seem trustworthy, and I'm sure you are, there are other actors out there, and this is somewhat of a precedential kind of a case. So we can't have different traffic laws for good drivers and bad drivers. It's kind of how it seems to me. And I've dealt with a lot of private sector clients that had to deal with reserve funds for landfill closures and so on, and philosophically there's a lot of resistance to it, but it's just kind of a reality of doing business here in California, as you mentioned. So I guess that's all I had to say at this point, and I think we have to have the same rules established across the board.
It's not very comforting to learn that you're precedential in nature. I understand that.
I will say that I mean, I've been leaning on Brad. Brad's been having this conversation with a lot of folks already, and it's a tough conversation to have. Carmen, I think you're exactly right. It's not something you want to hear, that, well, we've been doing business this way for a long time. All of a sudden, the regulatory agency is reassessing it. I think you know, at the end of the day, it's a public resource. Groundwater is a public resource. Surface water is a public resource. We have to do our job to protect that. There are regulations in place that dictate how we're supposed to protect that. And so when we miss the ball, even if it was years and years ago, we owe it to the public and the protection of the public resources to make sure that we have those hard conversations. Say, you know what, we were doing this for a while, but we can't do it this way anymore. We have to do what we should have been doing. So, like I said, Brad, Rob Busby, in his unit, they've been having a lot of these tough conversations, and even reassessing some financial assurance mechanisms in terms of the amounts as well. There's some that are undervalued, and those are a tough conversation to have. You know, you put $500,000 aside. Well, guess what? In 2019 dollars, it's $2 million. So we're going to have a tough conversation about how you get that done. Again, that's so programmatically we're doing that, and again, State Board is also programmatically reassessing these regulations and making sure they're crystal clear and represent, you know, California State Water Board and as vision for how they see these mechanisms be employed. And man, oh man, Title 27 is a mess. It's not very clear. It's not very well written. You know, it's tough to wade through from a member of the public or even from somebody with some sophistication in the regulated community. State Board has taken upon themselves to try and untangle that and make it a little bit more straightforward too.
When do we have a time estimate on when this financial means test might go away at the state level?
I know, and again, they've been having the scoping hearings and some listening sessions. I don't know what their ultimate timeline would be.
Are we under any potential, you know, appealability issue when we're not allowing somebody to take advantage of something that's still on the books?
I mean, I think it's an overstatement to say it's on the books.
Patrick, did you want me? I think I can answer that. So, I mean, yes, it is technically on the books, but only for certain circumstances.
So even as it's written now, it wouldn't apply to this situation.
Correct.
Even as it's written now. I mean, you go and, each of those sections under that menu of financial assurance options that's provided within each section, there are limitations for each one. For example, a local government financial means test can only be applied for, I believe, let's see, it can be applied for post-closure maintenance and corrective action, but it also can't be applied for operating liability or closure. So, I mean, at each level, the Integrated Waste Management Board, when it first implemented the Subtitle D regulations under the Federal Code for Municipal Solid Waste Landfills, made decisions about what mechanisms could be used for what purposes. And I would echo Patrick's comments and Melissa's comments that Title 27 is not a paradigm of regulatory clarity, but and it could go, it could go a lot further to really clarify things. But when they did promulgate that section, they actually, under the federal municipal solid waste landfill regulations, you can use the financial means test for any purpose.
Yeah.
And it was an actually conscious decision on the part of the state regulatory agencies to limit the use of that. And that's what's reflected in that regulatory history document I quoted in my presentation.
Well, and I appreciate that. And I guess what I'm trying to do is, I'm trying, my ultimate responsibility, of course, is to the state of California and the water of the state, right? And I'm just trying to make sure that if there's any way that we can be accommodating and still meet our responsibility, that we can. But if we can't, then we can't. But it feels, I'm just trying to.
One of the common themes
Getting
about
answers.
Title 27, it's very prescriptive. It says this is exactly how you have to operate, and this is exactly what these facilities must do. And that's kind of a two-edged sword, because there's many times in which staff want to make exceptions or, special dispensation or treat facilities differently, yet I mean, Title 27 is very firm and says you have to do X, Y, and Z for everything, and that's just a common theme of the entire regulatory.
Okay, thank you. Yes, sir.
Thank you very much. So I think putting the technicalities aside, and I understand the precedent issue, that's a big deal. But with our companies, the situation we did is we basically are in the process of building 15 acres of very high-tech ponds voluntarily, okay? Knowing we're going to close the oldest pond we have voluntarily. The other two ponds we built like 3 years ago. They're almost brand new also. We had to go to our bank and say, hey, we need $5 million to build these ponds. They go, why? Well, because it's the good thing to do. It's for the future. We want quality. We want growth. We want to close this pond. Why do you have to close the pond down? Well, we just think we're going to have to pretty soon. Would anyone tell you have to? No. So they lent us $6 million or $5 million to build these ponds. We didn't tell them. We've had 5 years of financial means going on. And now I go back to the bank and I say, oh, by the way, there's a $6 million liability attached to this. Whether it's $100,000 a year or not, you add it up, it hits the balance sheet. It's not going to be looked at well. And it's a serious thing. It's a very, very serious thing. Every penny you tie up in this situation means a penny we can't spend to do something that's right. Okay? So it's a big decision.
The other thing is we had this exact conversation here in 2014, and it was, the language was changed based on Musco's comments, and we provided the financial means test by the deadline, and they closed the pond. So between 2014 and now, they've been doing the financial means test, they've closed the pond, and so there hasn't, the world hasn't come to an end. The other thing is from your reading, there are things that you can use the financial means test for. So perhaps for the post-closure and the corrective action operating liability, we could use financial means test and use something else for the rest of it, so there's a compromise. Right now, the language in the permit is requiring us to come up with this plan by April. I think since it's something different and we're going to have to craft it with the regional board so that everybody is on the same page, it would be good if we could have an extension on that due date. And I think I asked the staff and they seem to be okay with that. But I don't want, I really hesitate to say that.
Okay, just a minute. I'm prepared to give Melissa more time and in fact ask her to make a closing statement. Is there any further, because I think you're in the midst of what would be your closing statement. Is there any further discussion you want to have with Musco on this? Anybody on the board? So go ahead and continue and recognize this is your closing statement.
Thank you. So I think wrapping it up, I think the footnotes that are in the text right now that say you cannot use financial means for any purpose, I think is inaccurate. I think there are places that are carved out. If you're looking at the very specific language that it specifically says for operating liability and for post-closure maintenance that you can use financial means. So perhaps there's a way to split the baby, allow financial means for parts that are specific, and some other mechanism for the remainder for closure and anything else that is on the list. But
If I could, I don't mean to interrupt, but the language of the footnote says the financial means test is not a financial assurance mechanism expressly contemplated with regard to either closure or corrective action. It doesn't say for any purpose.
Right, but corrective action to me is part of an operating liability.
I just want to make sure that
Okay.
That's
footnote
not
is quoted.
necessarily the case. Operating liability would be to a third party, you know, for property damage, which, you know,
It's the
obviously
state.
when you do corrective action, there may be when you do corrective action, there might be actual property damage as well, but corrective action is not limited to whether or not a third party's property has been injured or affected.
And then again, I don't mean to interrupt, but I just
We could keep going around and around on this.
Sorry for cutting you off.
That's all right.
You have anything further to say?
Well, I got cut off in the middle of what I was saying.
Again, very
so
sorry.
That's okay. So the point is that I think there's a way to potentially split the baby, use all different mechanisms, which is clearly allowed under one of the sections of that I had in my presentation. And then if we get asked for additional time, currently the date is April, that we have to come up with whatever the plan is, if we could push that back a little bit so that we could have a meeting with the water board before we propose something so we know what we're proposing is going to be accepted, so we don't have to chase our tails, that would be ideal. Thank you.
Okay, closing statement by staff.
Wait, can I ask for clarification? When Ms. Thorpe says a little bit more time, what does that mean to you in this universe?
Well, just, yeah, a few months. I know getting on Patrick's calendar is always challenging, so.
I saw I saw staff shaking their head affirmatively. Yeah, so
Yes.
I'm going to make another statement when you get done, but go ahead, closing statement, please.
Right, well, I want to thank Chairman and Board and Felix and Melissa for coming down. You know, as stated earlier, this WDR revision process was fairly amicable. You know, Musco approached us and said, we need to build 3 more ponds. It's not in the WDRs. And we went, okay, sure, we can do that. So we did it. We reviewed the file and where things are and, you know, found this financial assurance discussion, read the regs a lot, learned a lot about financial assurances in the last 6 months. And this is the direction we went, and I think we're reading the law correctly. You know, the footnote is not expressly not allowing closure or corrective act, or it states that closure or corrective action. Those are the scenarios where financial means test is not appropriate. It's not talking about the other ones. So we're fine with using financial means test for the other scenarios. And with respect to the due date, yeah, that's certainly open. Staff can meet with them and we can talk about it. And
We'd have to probably set a date, but I think we've said 3 or 4 months. Yeah. I mean, is that? Yeah, I think so. We could extend that by 2 months after, or 4. Huh?
From whatever they're
Yeah, so I guess it would be April 2019 for the due date for the financial assurances, plus 3, would 3 months be okay, or 4 months? July 17th it is. That's not a weekend, right? We know for sure. Fantastic. Okay, so yeah, we could do that. So it would be July 17th, 2019 for, and let me read out that provision. That would be in the tentative WDRs. That would be section, or page
David,
34.
let's let the board discuss it.
Oh, sorry.
And with that, thank you.
And the EO recommendation?
My recommendation is, and my commitment is to adopt the WDRs as written. I think they correctly state the regulatory provisions as applicable to this facility. But I do recommend changing the April 17 deadline for the financial assurances, which appears in several places in the WDRs, to the July 17th date. And my commitment is to engage with Musco, to engage with them to try and find a financial assurance mechanism that both protects the state's interest but has a minimal impact to the extent possible on Musco's operations and operating capital.
So I hear a commitment from the executive officer to actually continue a discussion. And I would expect that if you feel that you're not served by that, if this board does adopt this today, that you're going to be in front of this board. Certainly you can come back in the public session early in the morning and say that you don't think the board lived up to what they had said that they would do in working with you on that. My other thing I was thinking about, so much of this was a no-brainer and would have been on the uncontested calendar, and we're that close, unlike that other issue we had before you. And it would just be nice if this could be like ILRP yesterday, where I expected many hours and it turned out everybody was happy. Well, not happy, but they were going along with it. I was going to think maybe continue this to the end of the day, and you guys come back and say we agree to everything that with these changes and ready to go. But it sounds like with what the executive officer is saying, that that issue of providing the public with the assurance that in the future they are protected from charges that they might have to cover, and not 10 years from now, 30, 40 years from now, is going to be addressed. So with that, I will bring this back to the board. And is there any discussion? A motion?
Dr. Longley?
Yes, ma'am.
Sorry, over here.
Over there we go. I didn't look at it.
I just want to add, there may need to be one more change because on page 31, the due date of June 1st is for the discharger to report and confirm their chosen mechanisms. Since we're pushing back the April date, we should probably push that back to September 1st, equivalently. So
I would agree. Does that meet your requirement, Melissa? That change?
Yeah, that's fine.
Good, thank you. Anything else? Do I have
I
a
just say
motion?
I'm pretty encouraged that there's some potential here for cooperation and negotiation moving forward. It doesn't seem like an undue time extension at all, a few more months, and hopefully we can work it out, because I'm sympathetic to the business issues that you brought up, and I'm sympathetic to the precedent that we're establishing here too. And I don't know if you guys are planning to participate on the state board's review of Title 27 and their financial assurance discussions, but I'd certainly encourage that since it's ongoing.
And I appreciate, the commitment, and, to the extent that we can, I mean, you're exactly right when you said you can't have laws for good drivers and bad drivers, but to the extent that we can use, our judgment that we have as a board and that we delegate to Patrick to help determine when, we need to be really tight, and when a creative solution by maybe a good citizen is worth doing, then that kind of consideration matters. I mean, at the end of the day, like I said, it's still about water quality, it's still in the future, but to the extent that and the importance of this issue is another reason that taking it slowly and getting it right is a big deal. but it's just a hard decision.
I mean, I will, again, I pledge to engage with Musco in those discussions. The line is that no financial means test for closure or corrective action, but everything else is on the table.
Very good. Do I have a motion?
I'll make a motion to approve of the revised WDR with the date changes that we have before us. Is it June?
The 17 April would be moved to
July
17 of July, and the other deadline would be moved to 1 September.
I'll second the motion.
Denise has moved, Dan has seconded. Any further discussion? Call the roll, please.
Dr. Markham?
Aye.
Mr. Schneider? Mr. Bradford?
Yes.
Ms. Ramirez?
Yes.
Ms. Brower?
No.
Ms. Kadara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you. Thank you very much, and we wish you the best. And I would appreciate if you report back to the board the result of the discussion with
Absolutely.
Moscow. Thank you. Looking at the agenda and looking at the time, it's 20 minutes to 12. The Mule Creek item, I suspect, will take at least 60 minutes, possibly longer. I'm looking at agenda item 21, the annual enforcement update. How long will that take?
My guess is the DO item, the dissolved oxygen item, might be shorter than the enforcement item.
Let's do that then.
The staff's available for that. We'll be in touch. You have just 1 minute.
20, which one did he say? 20, 21. No, that's enforcement update. He said something else.
Kim, how long would the enforcement update take?
No,
Yeah, that's what I thought.
22. San Joaquin River. Oh, the DO one. That's what he said.
Sorry. The enforcement, for what it's worth, the enforcement item is pretty substantive, and it will include a bit of a discussion on post-fire activities, since Kim's unit was instrumental in doing some of that work, and so it is a pretty extensive discussion there. Not more than an hour, but probably not enough to squeeze in before lunch. Adam's finding the staff with the DO presentation. They can give that. That's about 15 minutes at most.
Notice the majority of the board said we have to be done by 3, since we have a long drive home.
We'll work on it. Lunch will be 5 minutes.
This time, the board will hear a presentation on the implementation of the oxygen TMDL in the San Joaquin River Stockton Deepwater Ship Channel. Information item only. No action will be taken. Board may ask questions and provide direction to the staff. Interested persons will then be allowed 3 minutes each to address the board. We're now ready for the staff presentation.
Staff is still making their way to the podium. Are they not there? Oh no.
So we're getting the presentation loaded up. It'll just be a second, okay? Almost, give me about 10 seconds. Do you want me to go ahead and get started? Dr. Longley? Should I go?
Let's go.
Okay. All right, this is an information item only. My name's Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office. Today I'm going to talk about the status of the San Joaquin River and Stockton Deepwater Ship Channel Dissolved Oxygen TMDL implementation. I'm going to primarily focus on the aeration facility.
We got your reinforcements, Adam.
Oh. Here I thought I'd get my day in the sun. Okay.
I apologize about that. All right, so this presentation will begin with a brief background of the dissolved oxygen impairment in the Stockton Deepwater Ship Channel, actions that have improved DO in recent years, and current DO conditions.
Robert, if you could, feel free to introduce yourself because you're not Adam Lapitz.
All right, my name is Robert McCarthy. I'm an environmental scientist at the Pesticide TMDL unit. With me is Danny McClure and Christine Job.
Thank you so much for getting it together in a jiffy. So I appreciate it.
All right, so we're going to go over this brief background. I'll then go on to discuss the TMDL that was adopted, as well as a control program for implementation. The background section will be followed by a short discussion of the aeration facility constructed and operated as part of the control program, along with the current status of its operations and funding. This is just an informational item for the board, and we're not asking for any decisions today. All right. Dissolved oxygen, or DO, in water is important for aquatic plants and animals. They need it for respiration, and low dissolved oxygen in the water can cause a number of negative effects on aquatic organisms. Our Sacramento-San Joaquin Basin Plan contains DO objectives for aquatic life. For the reach of the San Joaquin River and the Stockton Deepwater Ship Channel, we have 2 DO objectives that apply. Most of the year, our objective is 5 milligrams a liter, but during the fall, from September through November, the objective is 6 milligrams a liter. All right. In the Delta, the San Joaquin River from Stockton to its confluence with the Sacramento River has been dredged and deepened, forming the Stockton Deepwater Ship Channel. This figure shows in dark blue the section of the San Joaquin River in the Stockton Deepwater Ship Channel that has historically had an impairment for low dissolved oxygen. Since the mid-1930s and until recent improvements, the San Joaquin River near Stockton experienced regular periods of low dissolved oxygen that sometimes resulted in fish kills and delayed the upstream fall migration of Chinook salmon. The low DO conditions observed in the Deepwater Ship Channel resulted from loading of oxygen-demanding substances such as ammonia, algae, and other organic matter, reduced river flow through the channel, and channel deepening. So basically what happens in the Deepwater Ship Channel is there's a lot of algae and other organic matter. So when the San Joaquin River hits the dredged ship channel and slows down, it can become stagnant, and this leads to excessive algal growth, which eventually dies. And then the breakdown of that organic matter, along with respiration and other oxygen-demanding substances, use up a lot of DO in the ship channel.
Is that an actual picture of the fish? Can you say it?
Yes. Okay. So now let's take a look at the TMDL. In 2005, this board adopted a TMDL and control program for factors contributing to the dissolved oxygen impairment. The TMDL required that responsible parties must coordinate to implement control measures addressing the impairment. Oxygen demand studies are also required by entities responsible for point and non-point sources in order to identify and quantify the sources of those substances. The DO control program also stated that the regional board may consider alternate measures as opposed to direct control if the measures adequately address the impact on the low DO impairment in the Stockton Deepwater Ship Channel and do not degrade water quality in any other way. So in conjunction with other approaches, excuse me, the control program also contained a conditional prohibition of discharge of oxygen-demanding substances, which would become effective if dissolved oxygen objectives in the deep water ship channel were not being met. Since adoption in 2005, a number of actions have been implemented to address the DO impairment in the Stockton Deepwater Ship Channel. Regional board regulatory programs have included requirements in MPDES permits and waste discharge requirements to address DO impairment and implement the control program. The city of Stockton upgraded their wastewater treatment plant. This aeration facility pictured here was constructed at the Port of Stockton as an alternate measure of the control program to address the DO impairment. The aerator can be thought of as a giant fish tank bubbler that aerates the deep water channel. A number of studies of the sources and effects of oxygen-demanding substances were also completed. And as a result of the reduced discharge of upstream oxygen-demanding substances from point and non-point sources, as well as the operation of the aeration facility, the dissolved oxygen conditions in the Stockton Deepwater Ship Channel have improved significantly since 2008. This figure shows the monthly average of dissolved oxygen from 2001 through 2017, measured at DWR's gauge on Rough and Ready Island in the Deepwater Ship Channel. The blue line is the dissolved oxygen concentration, and the water quality objective is in red. Again, it's 5 milligrams a liter most of the year and 6 milligrams a liter September through November. In 2005, this board adopted a total maximum daily load, or TMDL, for DO in the San Joaquin River, shown in dark green. In 2007, an upgrade of Stockton's wastewater treatment plant resulted in a large reduction of discharges of ammonia, which significantly improved DO. Also in 2007, an aerator was constructed in the Deepwater Ship Channel by the Department of Water Resources using Prop 13 funds. After a demonstration period, operations of the aerator were turned over to the Port of Stockton in 2011. The Port of Stockton, with support from other stakeholders in the watershed, has been maintaining and operating the aerator since 2011. The DO has improved. The low DO we had up through the early 2000s is gone, and even through the recent drought, the DO is now consistently meeting standards. Dissolved oxygen concentrations in blue stay consistently above the water quality objectives in red. And since the DO has been meeting objectives, the conditional prohibitions of discharge have not been necessary. In 2015, the TMDL came before this board for reconsideration. At that time, the board recognized that dissolved oxygen levels in the Stockton Deepwater Ship Channel had improved significantly due to implementation of the control program. This board also recognized that, based upon information gathered during the control program studies, it was not feasible to revise the TMDL or control program. A resolution was adopted that supported continued implementation of the control program. So that concludes the overview of the background, and I'll pause now if there are any questions for staff.
Questions? The thing that here is, and it's in the buff sheet, that's important to me is the fact that the agreement to fund the operation of the aerators is voluntary. And if, but in fact, we don't see funds too long into the future for the continued operation of that. Folks have to step up to the table and participate. Otherwise, this board will have to take the appropriate action to ensure that we can maintain water quality in that ship channel. And I'm certain that the executive officer is keeping a close eye on that and will be back in front of this board if there is not some voluntary action taken. There's a lot of folks that have to participate in this. There's fingers pointed. There's yes?
I didn't mean to interrupt you.
But let me finish, and then
Yeah.
you can. There is certainly contributions by the agriculture community. We would hope that as the irrigated lands program progresses, we get better control on nutrients, that we're going to see an improvement in that. but nutrients coming into those waters encouraging algal growth are certainly part of it. But certainly also very important, other entities play a very important role in this, and this includes the flood control district, the city with its wastewater treatment plant that even though it was upgraded considerably, still has impact upon oxygen loading in the ship channel, the Port of Sacramento, and others possibly represent entities that are contributing substances which have an impact on the oxygen deficit.
Probably
the table that we're seeing. So
Port of Stockton.
I mentioned Port of Stockton, yeah.
Yeah.
All of those folks are part of this, and I suspect would be part of any kind of regulatory action that we might have, that we would take in the event that there's not a voluntary action here.
Absolutely, absolutely. And I just, again, I did not mean to interrupt. In the second half of the presentation, which Robert just about to give, we do have some updates, some positive developments. Jeff Winfield from the Port of Stockton is here to talk about the new agreement, which will also include a contingency fund. And so that's discussed. I think we've got a few more slides for you.
Okay, good.
All right. So now I'd like to discuss aeration in the channel along with the voluntary aeration agreement that provides funding for operations. In 2003, during TMDL development, a peer review of dissolved oxygen studies suggested aeration as a means of increasing dissolved oxygen levels in the channel. Aeration feasibility studies were undertaken, and a letter of intent to fund an aeration device was submitted to the board by interested stakeholders. In 2006 and 2007, the Department of Water Resources constructed a full-scale aeration facility at the Port of Stockton using $3.7 million in Prop 13 funds. It's typically operated in the summer and fall when DO concentrations in the San Joaquin River can fall below the water quality objective. Starting in 2008, the facility underwent a demonstration testing period, and the aerator was shown to be effective at increasing DO concentrations within the channel. In 2011, staff requested that interested stakeholders develop an aeration agreement to fund the operation and maintenance of this facility. The agreement was finalized in 2011, and the Port of Stockton, with support from other stakeholders in the watershed, has been operating and maintaining the aerator since. The aeration facility is located at the west end of Rough and Ready Island, the Port of Stockton, and due to tidal action in the channel, this facility has improved DO conditions throughout the surrounding ship channel. The facility is capable of delivering 8,000 pounds of oxygen to the channel per day. It works by pulling in water from the ship channel and injecting oxygen into that water, which dissolves under high pressure at a depth of 200 feet. The highly oxygenated water is then returned back into the deep water ship channel through a diffuser located under the docks. This figure, which appeared in the EO report, shows dissolved oxygen in the ship channel in 2018 and provides a good illustration of recent conditions and the effect of the aerator. DO is a blue line representing measurements taken every 15 minutes. The line's width represents the daily fluctuations in DO. Concentrations decrease overnight and then increase during the day. The red line is the water quality objective. The light blue shaded area shows when the aerator was operating. And towards the end of summer, as temperatures rise and flows are lower, DO starts to decline. When it approaches the water quality objective, the port turns on the aerator and DO goes back up. In 2018, the aeration facility was operated from early August into October for a total of 67 days. Due to aerator operations, there were no significant excursions below the DO objective. Since 2011, the aerator has been operated and maintained under a voluntary aeration agreement between the Port of Stockton and stakeholder groups representing discharges and water diverters in the watershed. And they are the San Joaquin River Group Authority, the San Luis Delta Mendota Water Authority, San Joaquin Valley Drainage Authority, and the state water contractors. The initial agreement was established to be effective from June 1st, 2011 to May 31st, 2014. The initial funding contribution per the agreement was set at $200,000 per year, with funding partners each contributing a portion of the annual commitment. The initial agreement has since been extended 3 times and will currently expire May 31st, 2019. A new funding agreement will need to be established before June 1st, 2019 to ensure continued operation of the aeration facility. Here's a table detailing the funding commitments from signatory parties. The table details the percentage each party paid of the annual commitment along with the contribution per year and the total paid over the first 3 years of the agreement. Support is also provided by DWR, which operates and maintains the DO gauges and conducts other monitoring in the river. This figure shows the amount of money in the aeration fund from 2012 through 2017. During the first 3 years of the initial agreement, a combined $200,000 was contributed each year by the signatory parties. Annual costs ended up being much less than expected, usually between $35,000 and $120,000 per year. So when the agreement was amended in 2014, funding contributions were no longer required. At that time, there remained in the fund approximately $490,000. Over the last 5 years, the fund has been steadily drawn down. At the start of the 2018 season, there remained approximately $145,000 in the fund. In March of 2019, the aerator operator, ICF, will release a summary of operations, maintenance, and costs for 2018, which we anticipate it being between $50,000 and $90,000. This would mean that there could be less than 1 year's worth of operating money left in the fund going into the 2019 season and the new aeration agreement. So to ensure aeration operations are continued, staff recommends that stakeholders provide adequate funding under a new agreement in 2019. Staff also recommends that a contingency or reserve balance in the fund should be established in order to cover unanticipated maintenance costs that may arise from aging equipment and unforeseen repairs. In a recent discussion with Jeff Wingfield from the Port of Stockton, who will be providing an update following my presentation, staff were informed that the funding partners have started meeting to discuss extending the aeration agreement. They are also looking to extend the agreement, likely for a multi-year period, including funding contributions and establishing a fund minimum. There are also some parties in the watershed who are not yet contributing to the aeration funding agreement, and so staff also plans to follow up with them. In conclusion, the control efforts have been successful. The dissolved oxygen conditions in the Stockton Deepwater Ship Channel have improved significantly since the adoption of the TMDL in 2005. Consistently meeting the dissolved oxygen water quality objectives will require occasional mechanical aeration. As long as these objectives are being consistently met, there is no need at the moment to trigger the conditional prohibition of discharge or other board regulatory actions. Staff appreciates the leadership role the Port of Stockton has taken with the aeration of the ship channel, but to ensure continued aeration, ongoing funding and a new agreement are needed. Staff will continue to work to implement the control program and support the new aeration agreement. And that concludes my presentation.
Thank you.
Any questions?
Any questions? You mentioned the gentleman who's here from Port of Stockton.
Yes.
I don't have a card. So introduce yourself, please.
Good afternoon. My name is Jeff Wingfield. I'm the Director of Environmental and Public Affairs with the Port of Stockton. We are proud of the success of this project and have worked very hard with the other stakeholders to put what we feel has been extremely successful. To go into the history of the agreement a little bit, I think when we initially went into this, there were a lot of unknowns. There were a lot of we weren't sure of the cost per year. We weren't sure of working with the new equipment that we were taking ownership from DWR. But over the last 5+ years, we've got it down to a pretty good science, and so things are working very well. We're working well together as a group. We recently met and agreed to move forward with another 3-year plus 2 additional year extensions and to provide additional funding. So I believe the fund is down to around $64,000 at this point. By May 19th, we will execute a new 3 to 5 year agreement and include another year's worth of funding to go into the account as well.
So you feel confident of that?
I feel very confident. We've met and there's been no disagreements whatsoever. We will execute a new agreement before the current agreement expires.
We're looking forward to that.
Yeah. The only thing that I would ask is we kind of look at this as a big party, an aeration party, and we would request that the board would extend an invite to others to come join our party and enjoy all of our great success. So,
bring your checkbook.
Yes.
Okay. Any questions?
I got a question. Is anybody doing any science experiments or observations on the effect of the aeration or the risk associated with if the thing breaks down for a period of time?
Well, I can tell you that it is broken down right now. We're actually in the middle of a repair. It's fairly simple, and thankfully the timing, it broke down towards the end of the dredge season, and it was some galvanized steel was put in a position where it shouldn't have been, and so we're going through the entire aerator now to see if there are any other galvanized steel, and just during our last meeting, I suggested something similar to like 100,000 mile tune-up on your car, that we need to go through the whole thing, analyze everything, and just make sure that we've got backup parts, and as well as surety that this thing's going to continue to work. And as far as the influence on the channel and DO, other than the samples, I can tell you from being at the site every day that a family of sea lions has moved into the area that apparently, has probably followed fish up, and that's the only environmental indicator I can suggest. There's a lot of fishermen around there too. But.
Very good. Any further questions?
I just noticed on slide 14, I noticed there were excursions above the water quality objectives even when the aerator was running or when it wasn't. Is there any value to operating the aerator longer than it's running, about 2 or 3 months now during the summer?
Yeah. Might go back to slide 14.
Those were, oops.
If you could introduce yourself.
Hi,
Right there.
Danny McClure, Senior Engineer in the Rancho Cordova office with the board. Oh, excuse me, Danny McClure, Senior Engineer in the Rancho Cordova office. There are excursions below the water quality objective, there, and those are, so this is every 15 minutes. Those are extremely minor excursions. I'm not sure if running the aerator would have probably prevented that. I don't think it would have, because it's, a flow-through system at that point. But those are, I think, like I said, that's every 15 minutes, so that's an extremely minor excursion there.
Yeah, I'm
It's
sorry.
not gonna have any
Honestly, I was
environmental-
reading the table backwards.
Okay, yeah, that would be bad.
Yeah.
Yeah.
Now that I see the table a little more detailed, thank you.
If I could just say something too, my name's Christine Job. I'm an environmental scientist. Worked on this program prior to passing it off to Danny and his staff. And the contractor, ICF International, which is the group that manages the operations of the facility, they have done a great job actually in running different scenarios, looking at the best, most efficient way to operate the facility to meet the water quality objective. One of the things we didn't get into necessarily was the design of the aeration facility. There's actually one U-tube that has two U-tubes actually with one discharge line, and so there's 2 pumps. And so sometimes what they'll do, depending on what the conditions in the water in the channel look like for water quality, they can sometimes turn both pumps on or one pump on when they see what the reaction is in the channel from the aeration operations. So sometimes some of these things that you see going up and down in the signal itself could actually be a little bit of the operations that they're doing, where they're running 2 pumps and they switch over to 1 pump. They will shut the facility off for a little bit once they've turned it on for a while, just to see the reaction of the channel and the dissolved oxygen. And if they see that it starts falling again, they reinitiate the aeration facility. So there's a number of operations that they're doing that might explain why you're seeing the signal.
Any further questions?
I have a comment. I was going to say that, sometimes sitting up here is, pleasurable, like when you see good news and things that are successful. Sometimes it's hard, but this is a great example of how, a problem exists. Sometimes we only get press or we hear about things that are wrong and things after they've become a problem, and, the public is outraged. And this is a great story. And the fact that, because we hear about aeration and the problems in dissolved oxygen all the time, And to be able to say that this was, operating and it's really doing what it's supposed to do, and people, or the entities that are involved generally recognize it as a successful and beneficial project is really maybe not refreshing, because we do get these often, but it's very nice to see. So I'm grateful for the presentation. Robert, you did a nice job, and I'm glad Port of Stockton's here.
Thank you. Thank you very much. I have a card from David Corey, stranger to the board.
Chair Longley, members of the board, David Corey, representing the San Joaquin Valley Drainage Authority. Boy, I've talked a lot on DO and TMDL, 14 years ago when this was in front of the board. I think, Chair Longley, you were on the board, I think, at the time, weren't you? And so was Member Snyder. You heard all of my analogies at the time, and you'll remember that I was not at all a fan of this TMDL. Thought you guys got the allocation of responsibility all wrong, and was pretty wound up about the whole thing. 14 years later,
I can't imagine you being wound up about it.
I could go back to those analogies. I can pull them back, and we can revisit that.
They
if
might
you'd
be
like.
on video somewhere.
Yeah. No, I think that was before video. So there was some contentious moments in this whole process in the history of it. But we really have a project here that resolves this water quality problem, does it in a very efficient and effective way. And, the Drainage Authority is certainly working with the port and committed to continuing to fund this for this next agreement. This is a success story, and really one that was much easier to just fix the problem than to continue to fight about it. So I do sort of smiled a little bit, Carl, when you talked about participation is voluntary. Sort of like participation in CV salts is voluntary.
Yeah.
All of those things that are voluntary. I would like to invite you to express or give that invitation to other folks and encourage them to voluntarily participate in this project, because there are other participants who aren't funding this. It's really a nominal cost if you spread it amongst everybody. And I think we can do that and keep this thing ongoing and making sure that we meet those commitments at the lowest cost and share that. So I appreciate that. And again, if you ever want to talk about the analogies on the TMDL, I'm willing to do that, but we won't do that today.
Very good.
All right, thank you.
Any questions for David? Thank you very much. This was an information item, and the question has come up: is everybody at the table who should be at the table on this?
That answer is no, and I will be getting out some more invitations to that party. I will say just a couple quick words. I joined the board about the time that this thing was getting underway. I've been working on this project as long as I've been with the board. It was one of the first projects I've worked on, and it is remarkable to see this as a success story. There was, as Christine said, there was a lot of questions with respect to fate and transport of DO, operation of the aeration facility, how it should be operated, who's going to operate it, how it's going to be funded. I do want to thank David for, I know we heard that yesterday, we don't like it, but we're going to do it. I think that was the attitude then, and thanks to his leadership and the leadership of the Port of Stockton, I think Jeff Wingfield and I have worked on a number of issues at the port, getting this thing up and running and making a demonstration to not just state agencies, but to federal agencies and to other folks who are interested in this type of work, that these type of solutions do work, is a really big deal. I mean, it's innovative. It had its problems getting up and running, and a lot of work went into it, and to make it the success story that it is today.
Thank you very much.
I've got a question for the EO. What's the hammer on this? Is discharge orders by various parties?
The hammer, glad you asked. That's why.
quality.
Generally speaking, when folks are unhappy, there is a hammer somewhere in the picture. Alluded to in this presentation is a conditional prohibition on oxygen-demanding substances upstream. What that actually means, and I recall a hearing, I think it was in 2010, it would be a fairly draconian measure to pull the trigger on that. It would mean that a lot of the ag users in that area would have to shut down their operations significantly or curtail their operations significantly if these DO objectives weren't met. That's the conditional prohibition. That's the hammer. And as Robert's presentation concluded, because we're hitting the objectives here, because everybody's funding the aeration agreement, we don't have to pull that hammer out of our back pocket. And I think that in and of itself is a success story.
Very good. I think we have concluded this item unless somebody has a comment.
I would just say the working with getting the other parties involved to contribute is one of the issues that
Right.
need to face. As David said, everybody needs to participate for it to work. So what are we going to be looking at to try to bring the other ones into the fold? That's on the coalition?
Yeah, there are some free riders out there, and I think the ones that have been mentioned are the Friant water users. But there's a few folks. Most of the main folks are at the table and have stepped up. There's a few folks who still need to attend the party.
Come forward and participate.
Absolutely.
Yeah. So, are there any items that are going to be discussed in executive session?
Not today.
So 40 minutes is probably enough time for lunch. Good. We will be back here at 1 o'clock.
Thank you.
Thank you.